Why you are getting them adjourned? For orders,
Lordship, the conducting council, Mr. P. Naik, is not available today, Lordship.
it is stated that conducting council, Mr. P. Naik, is not available because of some personal difficulty. A request is made to adjourn the matter. The other side
Given, Lordship,
has no objection. List after 3 weeks.
deeply.
Lordship, item number 9, my lord.
Hmm.
My lord, the affidavit on behalf of the health department is ready, my lord. We can file it within this week. Can it be, my lord, after 10 days in that case? I've taken
Standing council for the health department. Submit that the affidavit on behalf of the department is ready
My lord.
and would be filed within the course of the week.
Well, within this week, my lord.
Within the week.
Yeah.
Within the course of the week,
Yes, my lord.
list after 10 days.
Obliged.
Lordship, I beg to mention item number 11, the senior counsel of the of this present case is on bereavement, so the matter may be
It is
taken
stated
up on any day.
that, and arguing counsel, Mr.
S. Botakur.
S. Botakur is not available today. A request is made to adjourn the matter. 3 weeks as played.
Obliged.
May please Lordship. I look at item number 8.
Eight.
In this case, we will file affidavit to the Lordship.
Let the matter be called out. Let the matter be called out.
May please, your Lordship. Lordship, I beg to mention item number 33 of today's daily list.
Just
Lordship,
hold
the
on.
conducting
We are
council.
on, we are on the third page. We are on the third page. Yep.
32.
There's no mention next. Yes.
Please, your lordship. Lordship, I beg to mention item number 19, your lordship. Lordship, in this matter, we need to file our affidavit. in
This
reply.
matter is repeatedly being listed. If you are not interested, we'll adjourn it sine die. Repeated adjournments have been sought.
Some instructions are
Additional
awaited.
place for time. Repeated adjournments have been sought in this matter. Thus, the case is adjourned by 8 weeks.
Deeply obliged. Lordship, I beg to mention item number 20, 21, and 22. Senior
These
counsel
are-
S. Botakur is not present.
It is stated that arguing counsel, Mr. S. Botakur, is in bereavement. A request is made to adjourn the matter. List after 3 weeks.
Obliged.
Yes.
May please, your Lordship. Lordship, I beg to mention item number 33 of today's daily list. Lordship, the conducting council, Mr. P. Nayak, is out of station, your Lordship.
It is stated that Mr. P. Naik, Standing Counsel Finance Department, is not available today. A request is made to adjourn the matter. The other side
Lordship, we have informed the other side. Lordship.
has been informed.
I am for deputation.
List of 3 weeks.
Deeply obliged.
Daily list for orders item 1.
Yes, Mr. Das.
Some Milord survey was conducted yesterday.
Hmm.
Yes.
And they have given one communication, perhaps there is.
Yes. But I have also got the
Basically, they want the
proposal and
fresh map from the IIT because they have checked up how much land it will have to be Milord left by the.
The bigger issue is we directed, there was a doubt expressed whether the private party who is claiming to be owning that chunk of land, which is the corner of the road, whether the revenue records reflect that position or not.
So far as that has not been written here, but so far as my knowledge is concerned, Milord, their boundary wall is intact, wherein as per the revenue map. That is my information. Subject to what my friend says.
the revenue authority, they also visited yesterday. Well, the proposed alignment now and the earlier alignment that has been given in the diagram,
Hmm.
and the report they have given,
Yes.
possibly this topic was already it is in the record.
We'll again send it to the Building and Infrastructure Committee. What else?
Well, they said that now the proposed change in the alignment, that they want to just verify from the
IIT.
IT engineer.
But then,
That will take 3-4 days.
if the issue of the land is not resolved before that, what is the purpose of getting the report from IIT?
No,
And
but-
again, you will require a fresh
No, but they
report.
have already changed the alignment because
They have changed by accounting for the private land.
that portion, we just don't want to touch it, because the alternative then if the High Court is.
Has
able-
High Court has agreed?
Yes,
What is the status?
My lord, so far as
That is the understanding on.
there
last
is no
occasion.
decision from the High Court as of now, your lordship
So then
wanted
let
to
the
know.
Building and Infrastructure Committee, all right,
Yes,
Mr.
your lordship wanted
Not
to know
sufficient.
how much land.
That a fresh survey, the report has been prepared and will be submitted to the IIT Guwahati for preparing a design of the new proposed alternative alignment. And the exercise will take another week. In view of the peculiar facts noted above, let the matter be brought to the notice of the Building and Infrastructure Committee of the High Court to re-examine the matter, re-examine the entire scenario in light of the contentions noted on by this court on 28/7/2023.
Yes.
List after 2 weeks.
Deeply open.
Item number 6.
Service report,
My lord, I was directed to, my lord, Basti also. I have done that, my lord.
you have not
I
filed
filed
the,
an affidavit yesterday.
you have filed the affidavit.
Yes, sir, yesterday.
Mr. Roy submits that affidavit of the Dasti service on the respondent has been furnished in the registry yesterday. Let a report be made on the affidavit and the matter will be listed thereafter.
Item number 7.
May I please go?
Report number 7.
Yes, lordship, my lord, I have already taken steps, lordship, yesterday. Lord.
And
Uh,
counsel
post
for the
admission.
petitioner state that steps for service on the respondent number 7 have been taken yesterday. Let process be issued. Rule is made returnable in 4 weeks.
I look.
Item number 8.
Yes, Lordship. In this case, we'll file affidavit today, Lordship.
Today,
Today, Lordship.
counsel for the petitioner.
We were supposed to draw up the portal for the students in the school.
Hmm.
Yesterday I had a discussion. It might take another 4-5 weeks. My lord, we'll have the portal ready. We'll have the SOP ready.
And counsel for the petitioner submit that an affidavit has been filed on behalf of the petitioner today.
Today, sir. Lordship.
Mr. Mozumdar submits that the process for opening the portals in the respective schools, portals reflecting position of RT admissions.
Yes.
In the respective schools are in the process of being opened and about 4 weeks' time is required to complete the same. List of 4 weeks. More or less, the things have been settled. We
Yes.
just let this process be put in place, then we suppose there should not be any further.
Things, one, the portal to be open to public and the other, the SOP with modifications as per the Supreme Court.
Yes. All right.
Item number 10.
Service on respond number 8. Do you want a fresh service
have
or
taken the
fresh
steps.
notice?
Steps has been taken, your lordship. Steps has been taken, your lordship,
Steps were taken when? Because the notices were issued in June.
my lord.
Now we are 2 months down the line.
No.
Should we direct fresh
No, my lord, I have taken the steps, your lordship.
await return of notice issued to the respond number 2, respond number 8
This is the,
for 2 weeks? All right, we'll await notices.
Item number 12.
So this was again the single judge decision to grant promotion, my lord, and my lord, no reasons are required for selection. There are Supreme Court judgments to the issue, and the rules, my lord, do not require any reasons to be recorded.
But then why you have denied? Satisfy the court.
My lord, we produced the record,
Yes.
the mark sheet was.
You did not file an affidavit.
No, my lord, we didn't get the opportunity. We were asked to produce the record only. My lord.
Hmm.
So, my lord, it was disposed of at the motion stage itself at
Hmm.
that point of time. So, my lord, we did not get the opportunity to file an affidavit. Otherwise, we produced the records in original that is recorded in.
Come to page 4 of the impugned order.
Yes, ma'am.
Record produced by Mr.
Yes,
Ganguly.
the report produced by Mr. Ganguly reveals that there was no cutoff mark fixed for consideration of the candidature of the officers who had appeared before the selection board. As a matter of fact, rules of 2007 also do not permit fixation of any such cutoff mark for promotion from MMG scale 3 to scale 4. Careful examination of the departmental records goes to show the selection board had not fixed any criteria based on which candidates scoring marks below a particular level could be denied promotion.
Hmm.
If that be so, the above action of the respondent, so and so, without applying any transparent and reasonable criteria in the face of the record, appears to be arbitrary. My lord, there is no question of marks here. We did not say because my lord, the rules do not permit us.
So why did you deny him promotion, sir? Satisfy us now.
My lord, the fact of the matter is that,
Yeah.
my lord, I have annexed the marks table. The petitioner was at serial number 7. We only selected.
You had got 11 posts.
But we interviewed, and this interview was not conducted only by the chairman of this bank. There were senior officers from 2 other banks as well, my lord. Lordship will kindly come, my lord, to the notification, my lord, at page 17. That is at annexure 1. But we clearly said in the notification itself that we reserve the right to reduce the number of vacancies, my lord. At the end, my lord, Lordship will find, this is the notification dated 12/10/2022, my lord.
In case there is shortfall in candidates
No, not only that, my
found
lord.
suitable for promotion.
Yes, my lord, applying for promotion vis-a-vis the declared number of vacancies. My lord, it was clearly stated that we did not find him and 4 others, my lord, suitable for promotion.
Let us read that conclusion, that you did not find him suitable.
My lord,
Where is that mentioned in your minutes?
No, that is not the because my
Then
lord,
that's not recorded, then there is
my
no
lord,
reason.
my lord, we were not permitted. We did not get the chance to file an affidavit.
You file all your record here. That
We-
will be reflected from your minutes. Read the minutes of meeting. Page.
No, minutes of the meeting, my lord, were not there. The tabulation of the marks is there, my lord. That is at page 39.
Where was the decision taken, Mr. Ganguly, that he is not suitable? So we are reducing the number of vacancies. That has to be there in
Yeah, that
accordance
is
with your guidelines.
Yes, my lord.
So
that
where is
there.
it? Let us see.
My lords, apart from 39, my lord, we did not produce anything before the learned single judge to that.
Page number?
39, my lord.
Let's read that.
39, my lord, is the
Tabulation.
final, yes, final
right.
tabulation, my lord.
Hmm.
And this, my lord, performance out of 60 is based on the previous 4 years, my lord, the annual reports of the 4 years. So annual reports of 4 years read with the personal interview. There are 2 issues here, my lord. So interview was not the only, my lord, criteria here. His performance over last 4 years.
Criteria has to be reflected somewhere, Mr.
Yes, my lord, that is reflected, my lord. The performance, my lord, was also considered. In the last 4 years, he got, my lord, he got in that category 43 only. my lord.
Yes.
That is, my lord, this is based on the performance of the last 4 years, based on the annual performance reports, which are produced, which are, my lord, seen by the committee. Now, whatever was seen by the committee, my lord, the learned single judge did not go into the entire aspect of the matter. my
Already issue notice to the respondent.
lord. My lord, the direction for promotion, my lord,
Let him come up for contempt, then we'll see.
my lord,
Notice
that
on there for
observation,
interim relief also.
my lord, no, there is an IA in which I filed, my lord, for those 2 documents which we could not produce before the learned single judge. No, that perhaps may be
That
disposed.
I also notice will go.
Lord.
Notice of the interim application also may be issued.
Obliged.
Issue notice of the IA as well as of the writ appeal to the respondent. Who is made returnable in 6 weeks. Steps for service be taken in 7 days. Whereafter process be issued.
Item number 13.
May it please your lordship.
But challenge was to the show cause notice.
Lordship's
It has
challenge
been
was, to
turned
the-
down on the ground that it was premature.
lordship's challenge was also to the Caesar, my lord.
Hmm.
Our contention before the learned single judge was this, my lord, that the Caesar is bad in law.
Why is that so?
Why? This is because,
Mr.
my
KL,
lord,
we have decided here that Mizoram Caesar matter.
No, let.
Lord.
Same issue. What is the basis of the Caesar?
Here, Lordship, there was a input that we produced before the not single judge also, Lordship. As well as we also challenged the maintainability of the repetition. And we produced all the documents before the learned single judge.
What
In
doc?
that case, Lordship, that was different. Here, Lordship, by chance that was seized.
Hmm.
Here, specific information was there. In the wagon, one railway wagon, the goods were seized. And there was a.
Then they have produced the documents. They have produced the documents.
No, Lordship, here, Lordship, that is not correct. The Lordship, allow me, I'll produce original record. If you allow.
Didn't you file your affidavit?
Yes, in
before
that case,
single
we
bench?
file our affidavit.
That affidavit is annexed, my lord.
Hmm.
It
In the
is-
affidavit also, my lord, no such reasons have been given, my lord.
The reasons you go and reply to this, respond to the show cause notice, they will decide. Why have you come in the red court even before the show cause notice proceedings were concluded?
Lordships will examine the records, my lord. This
What
is
for? What
Lordship-
for? That
lordship,
opportunity is there with the adjudicating authority.
lordships,
Jurisdictional authority will decide.
lordships,
Let
lordships,
there be an order at least. Why are
Yes,
you,
that is
you are in such a hot haste?
lordships, in my most respectful submission, my lord.
Hmm.
There is an instruction of the central board, my lord, central excise board, my lord,
Hmm.
which is at page, my lord. Lordships will kindly turn to page 96, my lord.
Yes. 96.
Lordships.
What is the instruction? Let's see.
Now, lordships, this has been issued, my lord, under section 151A of the Customs Act.
Hmm.
It's been issued, my lord, by the lordships, by the Ministry of Finance, my lord. That is Central Board of Excise and Customs, my lord.
Hmm.
Now, lordships, this instruction is mandatory in nature, my lord.
Hmm.
This instruction dated 8 February 2017 states, my
Here
lord,
there is a seizure.
lordships,
You don't dispute, so this instruction, how does it help you?
lordships, I'm coming to the instruction, my lord.
Hmm.
Lordships will kindly turn to, my lord, paragraph 2 of the instruction.
Hmm.
It has been brought to the notice of the board that in several cases, goods are being held up, seized by the field formations only under Panchnama, and separate orders for seizure of goods are not being passed.
Hmm.
The Honorable Delhi High Court in a recent order has held that a Panchnama is statement of Panchas and cannot be taken to be an order passed by proper officer under section 110 of the Customs Act. Though section 110 of the Act EB does not specify passing any order for seizure of goods, it says that where it is not practicable to seize any such goods, the proper officer may serve on the owner of the goods an order that he shall not remove, part with, or otherwise deal with the goods except with the previous permission of such officer.
Hmm.
Now, lordships will turn to paragraph 4, my lord.
Hmm.
In view of the above, in all future cases, the following may be adhered to.
Hmm.
Whenever goods are being seized, in addition to Panchnama, the proper officer must also pass an appropriate order clearly mentioning the reasons to believe that the goods are liable for confiscation.
Hmm.
Now, lordships, in this case, my lord, no such order is passed. Now, lordships, when no such order is passed, this instruction which is mandatory in nature is
That
becomes
order will follow once the show cause notice proceedings are over.
lordships.
Does the instruction say that right at the time of the preparation of the Panchanama, the seizure memo must be prepared?
Lordships,
Or can it be passed after the show cause notice proceedings?
no lordships. It cannot be passed after the so-called notice proceedings.
Okay,
It has to be passed at the time of seizure. Now, if this instruction is not complied
now
with,
who is the learned single judge dealt with this instruction?
lordships, this aspect has not been dealt by the learned single judge.
Yes, Mr. KL, what do you say? Where is
Lordship,
the seizure?
Lordship, may please come to page 100, paragraph 3 of my affidavit.
Page 100.
Yes, sir. The part of affidavit, filed by the department.
Yes.
Paragraph 3. The para A.
So where is the seizure memo?
Lordship.
Seizure memo, my lord, is it?
We'll produce the original records, Lordship, because we challenge the repetition
He
of the.
says
grounds of
that without mere preparation of the
It is-
Panchanama,
it is there, Lordship.
without recording a satisfaction. Let us read the Panchanama once.
Lordship, order of seizure is also there, but reasons
Where
are
is the
not.
order of seizure?
Lordships will find it page, my lord.
Page 110.
Page 97, my lord. This is the seizure memo, my lord. Except this document, no other document is there, my lord.
Hmm.
Lordships will see, my lord, 5, reason of seizure illegal import, my lord.
Hmm.
Now, lordships,
That's what they're saying.
lordships, this is not the reason, my lord. This is the final belief. illegal import is the final bill.
Suspected illegal seizure. What is the show cause notice? Let's read that then.
So cause notice, Lord, he
Read
is
the
not,
show cause notice.
he is not annexed.
Lordships, I have
Show
not
cause
annexed,
notice, you have not even next.
not annexed, my lord.
Then your
Lordships,
petition is not maintainable otherwise also.
Lordships, I will annex the so called notice. I will find an
What is
additional
your
affidavit.
prayer? Let us see in the petition.
Prayer is to set aside the seizure, my lord.
Without challenging the show cause notice.
Lordships,
That's really strange.
It was annexed with the writ petition. Lordship.
It was annexed.
It was annexed with the writ petition.
So then it has not been filed along with the appeal.
no, not
why?
the file, my lord. Lordships, we are concentrating just on the seizure, my lord.
Even if there is any document which is a part and parcel of the writ petition, that has to be filed along with the writ appeal. And counsel for the petitioner shall file all documents which were annexed with the writ petition on record of this writ appeal. List after 2 weeks. Including the show cause notice.
Item number 14.
Yes,
Please, your lord. My lord, this appeals arising out of the common order, my lord, against which, my lord.
what is substantial question of law?
My lord, in similar matters, lordship, your lordship has formulated the substantial question of law, my
Mr.
lord.
Roy, what do you say? We should admit the appeal. The appeal is admitted on the following substantial question of law. As Mr. Chair Council, Mr. Roy appears for the respondents, notice need not be issued. Date of the order will be same.
Lordship. Lordship, let it matter be tagged with.
Connect
item
with
number-
so and so.
My lord, in fact, item number 15, there is an IA, my lord, for dispensing with the, my lord, filing of without the certified copy. That may be closed, lord.
The IA is closed. The appeal is admitted on the following substantial question of law.
Deeply applied.
They must have a copy to us.
Copy
Will, sir.
of the appeal and the annexed documents be provided to and senior counsel presenting the respondent, appealing on behalf of respondent.
Deeply applied.
Item number 16.
May I present? Lordship, we have tenancy GREF border organization rules of 2012. Lordship, we are welder serving in GREF. Lordship, under the rules of 1996, when we had joined, Lordship, there was a promotional avenue available to us from the post of welder to the post of charge mechanic, Lordship. Now, Lordship, with the coming into effect of the 2012 rules, the entire promotional avenue which was available to us has been done away with. And we have been stranded with no promotional avenues for the rest of our career. Lordship, and we had preferred representation, Lordship, communication was made that.
Are you aware of the order
Lordship,
passed on 30th June? Are you aware of the order passed by this court on 30th June? Probably no one appeared. You're not having a copy.
Lordship, on 30th June, I had appeared.
So read the order. What was the order?
Lordship,
You are having a copy?
Lordship, the honorable court was pleased to ask me as to what legal right do I have,
Yes, without challenging the rules.
Lordship.
Hmm.
Lordship, the communication made by the after our representation, Lordship, a communication was put forth that even if there is no because there is no rules providing for a promotion, therefore we could not be promoted. However, a case was projected by the authorities themselves that a promotional avenue in respect of welder grade 2 and welder grade 1 can be created so as to accommodate us and to avoid.
Can be created, then you want a direction to read certain clauses into the rules. That such scope of revenue promotion should be created in the rules. There has to be a prayer in the writ petition. Let us see.
Lordship,
Let's see the prayer.
Lordship, page 21, Lordship.
Yes.
Lordship, we had prayed for amending the rules to the extent that.
Well, that's your choice, sir. There's no prayer in your writ petition.
Lordship, in page 23, Lordship, down below, Lordship.
Yes.
To alternatively direct the respondent authorities to implement the suggestion made in the communication dated so and so for creation of promotion post of welder such as welder grade 2 and welder grade 1 similar to the promotional avenues in the rules of 2004. That communication is at Lordship page.
All right, then yes, gentlemen. Do you want to respond?
Lordships, on the last occasion, your lordships were pleased to direct him.
They have made a prayer that such and such clause should be or the avenue of promotion should be read into the rules. That is as good as challenging the virus of the rule.
Lordship,
To read something into the rule.
Lordship.
So that prayer is there. Issue notice, Mr. What's your good name, sir?
For all the respondents, Central Government Council, DC Bora.
Central Government Council, Mr. DC Borua appears on behalf of all the respondents. Sufficient copies of the writ petition be provided to him. Mr. Borua prays for and is granted 6 week time to file affidavit on behalf of respondents.
Obliged.
Item number 17.
May I please, your lordship? My lord, in this proceeding, my lord, we are challenging, my lord, the provision of the rule, my lord, rule 28(3), my lord.
Of the provincialization, my lord.
Few more writ petitions of same nature. No,
Some other rules have been.
Some
changed,
other
but of
rules
the
have been
same act, my lord. That's before the special.
My lord,
bench.
Here in this
special
case,
bench.
That is
here in
before
this case, my lord, I am originally, my lord, a head teacher of an ME school, my lord. My school, my lord, has been, my lord, amalgamated with a higher secondary school, my lord. As per this rule, my lord, I will be there, my lord, as a vice principal. But I will not get, my lord, scale of vice principal. I will get the original scale.
File your reply, Mr. Mazumdar. Issue notice, already notice has already been issued. Mr. Mazumdar appearing on behalf of the education within bracket secondary department,
Secondary.
Second one.
and MSP, RB Bora appearing for the respondent number 2. Mr. Nayak will be appearing for respondent number 3. Then standing
Finance
respective standing council appearing for the respondents, pray for and are granted 6 weeks time to file affidavits on behalf of the departments. List of 6 weeks.
Oblige, ma'am.
Item number 18.
May please, your lordship. My lord, in this matter, my lord, during the pendency of the appeal, my lord, the appellant has already been appointed by the respondent authorities, my lord. So, my lord, the appellant may not want to pursue the
Then
matter
counsel
further.
for the appellant fairly concedes that during pendency of the appeal, the appointment as
As my lord, constable, my lord, AB.
as constable
Yes. in the
has
Assam
already
police.
been offered to the appellant and thus, cause of action does not survive in this writ appeal. In view of the statement so made, proceedings of this writ appeal are closed.
Highly obliged.
Supplementary list, item 35 to 39.
Here, there have been certain developments post the filing of the writ appeal and even now, my lord. I had a talk with my senior, my lord. Perhaps a week or two's time, my lord, I can bring on record those developments. It just came up yesterday in the supplementary list, my lord. I could not bring it all on.
Mazumdar submit that in the intervening period, during pendency of this writ appeal, there have been certain developments which are required to be brought on record
My lord.
for consideration of this court.
Actually, my lord, what had happened is that they were challenging that requirement of TET for regularization. Now the stand had been taken before this honorable court that we are doing away with. the
Doing
TET.
with it.
That part, my lord, I have to discuss with the government and bring it on record. What will be the consequence?
Now,
of
these
this.
matters will regularly come up. We have now prepared a list
My lord, yes.
of the oldest matters first. They will be listed at top of the list every day.
May I suggest one thing?
Yes, please.
That's very nice, because if your lordships can have a list and.
That list will come, sir. That list will come.
And then matters are taken.
That list will be published, sir. Just give us a day or two. That list
I
will
know,
be
no,
published. You
that's
can take out the files.
That is
Yes.
a good idea.
Yeah, you can search your godowns for the old files.
Because earlier that was the practice, and fortunately, he didn't tell me at night. He got the list at 10 o'clock.
And it's
And
okay.
at
It's okay.
morning 9 o'clock, I said that.
We'll give you that accommodation.
have
That's
a-
not
we have a-
this is just the starting of the
I
process.
know, but
whereby
that is
we'll
good
try and
start.
at least bring the old files
Right,
to circulation.
Absolutely, absolutely.
Yeah.
So 35 to 39.
Yes. List on. List, Mr. Mazumdar, when?
Lordship will give me a week's time, my lord. at least.
List on.
Take 2 weeks
Nine-
because
uh,
you have not been in it in 2 years.
22nd August
Well,
at
let
top of
me
the
2
list.
weeks suggestion of my senior. Well,
Because
Let me
they have
2 weeks.
not been, we made an offer in one of the cases concerning mothers, Milord, for 4,000. They are not taking that decision as yet, so I am saying don't take 1 week, you take 2 weeks at least.
We are giving them time,
Yes.
22nd August
That's,
at top of the list.
so this will cover 35 to
39.
Yes.
40, 35 to 40.
40,
39.
39,
40 is another issue,
40 is another issue.
but we'll have the same prayer, Malad. We have the same prayer on that.
40 only has to be,
All right.
After 2 weeks time.
35 to 40.
The old dust has to be.
Yes, yes. And it can be clean, Milord,
Yes.
subject to what they say.
That during
Obliged.
pendency of the right appeal, there have been some new developments which are required to be brought on record. He placed for and is granted a short opportunity to do the needful list on 24th August at top of the list.
Oblige me.
Obliged.
For hearing in the top of the list category. 44, have you joined? The council may be appearing through VC. 44. No. Okay.
Item number 41.
May it please, your Lordship.
Yes, please.
Lord, the appellant before your Lordship, its Department, Food Safety and Standard Authority of India.
Hmm.
On the last occasion, my lord, the respondent was,
Not there.
yes, my lordship.
What is the writ appeal about?
My lord, the deputy director, my lord, he was, my lord, an employee, my lord, committed, my lord, certain, my lord, he spoke.
Council is here.
Yes, your
You ready, sir?
Yes, your Lordship.
All right.
So the matter was basically misconduct, my lord.
Misconduct.
Yes, my lord.
He was a permanent employee or what?
Contractual.
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 Then what you did?
Lord, we gave him an opportunity. And my lord, subsequently, my lord, he considered by a reply that it was an outburst.
Okay.
And then, my
What
lord,
was the misconduct attributed to him?
my lord, he gave some comments, my lord, saying that the deputy director, he belongs from Nagpur. And he's, during an argument, he said that Assamese people are being subjected to harassment in Nagpur.
Okay.
And that is why, my lord, a memo was drawn, my lord. Subsequently, he was, my lord, terminated from service.
All right.
And he filed an, my lord, writ petition.
Mhm.
He got an interim order from the court, my lord. And he got
But
a,
for 16 months, he did not.
he did not, my
resume-
lord, resumed office, my lord.
All right.
And in the year 2017,
Hmm.
for the first time, he resumed office, my lord. Then this matter came up. We placed that particular aspect that he didn't resume the office for last 16 months.
Hmm.
And the honorable court, my lord, said that his, my lord, the prayer for, my lord, his application may not be acted upon.
Hmm.
And then, my lord, this final hearing took place, my lord, wherein, my lord, an order was passed. Direction was given for reinstatement, my lord.
Hmm.
His tenure comes to an end in December 2017.
Right.
And December, my lord, 20 December 2017 itself, my lord, an order was passed for reinstatement.
Okay.
And my lord was, we were directed to pay 50% of
Back wages.
my lordship.
All right.
That is why this appeal, my lord.
So then you have not continued him after December 2017?
He never came, my lord, after that main order also.
He never, main order also, he did not come.
Main order, my lord, he didn't came. My
All right, where
learned
have
friend
you
would be the
pleaded
best
so?
person to say, my lord.
Where have you pleaded so? Let's see.
My lord, he had preferred a writ appeal, my lord.
He also preferred.
He preferred a writ appeal wherein, my lord, an order was passed, my lord, that his application may not be acted upon. Challenging that, he filed a writ appeal, my lord.
Where is that?
And that, my lord, that order, prior to that, if my lordship may for a moment, comes to page number 105.
Mhm.
That is the order, my lord,
Just.
page 105.
Hmm.
Page 106, my lord,
Yes.
relevant part, my lord.
Hmm.
para 4, notwithstanding the stay order passed by the court on 14/8/2015, the petitioner continued to remain absent. And only after 16 months, he recently reported to resume his duty on 2/1/2017. This was considered to be highly irregular, but in deference of the court's order, the belated joining report was accepted, but simultaneously an application has been filed for recall of the interim order under the given circumstances. Then, my lord, para 7. Considering the above and noticing that the petitioner was irresponsible and has failed to resume his duties and reported after several months despite the
Need
interim
not be
order
acted
passed
upon.
in his favor on 14/8/2015, the recent joining report 2/117 need not be acted upon by the employer at this stage. Then, my lord, he preferred an appeal in the said order. My lordship will find at page 111.
Yes.
Fourth para, my lord. Insofar as the present appeal is concerned, insofar as the present appeal is concerned, Mr. Goswami submits that consequent upon the order dated 27/2/2017, the appellant has received a letter from the employer, that is Food Safety and Standard Authority of India, NEA, directing him to refund the remuneration which has been released and transferred to him his bank account on 23/2/2017 for the month of January 2017. On this count, Mr. Goswami submits that appellant, after having resumed duty on 2/1/2017, worked up to 15/3/2017.
If the appellant.
Yes,
There's
my lord,
also
that is his,
question mark. Then.
that is his, my lord, his submission, my lord, that from 2/1/2017, he worked up to 15/3/2017. And this particular order was passed on, my lord.
28/3.
Yes, my lordship.
Then 24/3/17.
Yes, my lord. 24/3/17, this order was passed, my lord. And he was asked to, we were asked to, my lord, reinstate him. And my lord, his tenure completes at, my lord, 31/12/2000.
No, where is the direction to reinstate?
From, my lord, 24/3/17 to, my lord,
Where is the direction to reinstate?
my lordship will find at page 101, my lord. 101 is the order. I'm sorry, my lord.
That is the final order on the writ petition.
Final order, my lordship will
Let's
find
see
at
that.
page 23.
No, this is not the final order.
Final order 23, my lord.
Where is the final order on the writ petition?
23 page, my lord.
Page 23.
My lordship.
Final order is
Then
20th,
page,
20th December.
yes, my lordship.
Paragraph.
Paragraph, my lordship will find paragraph 14, relevant part, page 32. Page 32. First. Page 32, my lord. First para, last 3 lines, my lord. In that view of the above, the impugned order dated 22/6/2015 is hereby set aside and quashed, and the petitioner shall be reinstated forthwith. Then, my lord, para 15. Then para 15, my lord. Operative part, having considered the fact that the petitioner, even after obtaining stay order from this court on 14/8/2015, failed to join his duty for about 16 months and approached the respondent authority with joining report only on 21/1/2017. Therefore, the petitioner will not be entitled to any back wages for the intervening period with effect from 14/8/15 to 2/1/17. However, considering the fact that his termination is found to be bad in law while the petitioner admitted is again out of service since 16/3/2017, ends of justice would be seen if he is given 50% of back wages with effect from 17/3/2017.
17/3/2017. Okay.
And, my lord, para 16, it is also noticed that contract appointment of the petitioner is only for
Now that
3
we have
years.
seen discretion of the authority, yes.
That is,
Okay.
my lord.
So now what
From
is your grievance?
17/3/17 to 31/3/17, 50% of the back wages, my lord.
31/3, not 31/3, 31/12.
17, my lord.
12, yes.
12.
So you use his services and give him 50% wages. What is the problem?
My lord,
That is the import of the order.
after 17/3, my lord, earlier the interim order was passed. He never came, my lord.
So that's what we are saying. So he has not been held entitled to the salary for the previous period.
So far as we have dispersed the salary with from Milord, the January to.
That was
March.
under the division bench order.
That- Yes, Milord.
So
that-
forget
that
about
we
that
are-
part.
That we are not,
From 17/3/17 till presuming that he worked till 31st December. You have been allowed to give him only 50% wages. Why you are agreed?
but Milord, our concern is not that, Milord.
Then
Our concern is that, Milord, he, at the first point of time, Milord, our contention is that the order which was passed. it was
termination order.
Termination order, which has been set aside by the honorable single bench, Milord.
Hmm.
That termination order was rightly passed, Milord.
Now, what
Considering-
difference is it going to make? Tell us. His service tenure has come to an end. Why you are after the skin of a contract?
Milord, but he never, Milord, that, our contention is that, Milord, no work, no pay.
What? But he has worked for the period from January 17 to December 17. There is no
Milord,
dispute.
17/3/2017, his own everment, Milord.
Oh,
His own
Gentlemen,
everment. 17
Can we forget-
2017, we paid him that. We paid him for that,
2/1/17 he joined,
my lordship.
right? So 2/1/17,
From till 17/3/17,
yes.
we paid him, my lord.
So you
Yes.
paid him from 17/3/17.
17/3/17, my lord, till 31/12/2017, 50% of the back wages, my
So
lord. We are
why-
concerned with that only. my
So
lord.
why
Leave that
you are
aside.
bothered about it? He has worked or not?
That my friend will be the best person to say, my lord.
But it is for you to say whether he has worked or not. You are the employer. Do you know that he reported for duty after that or not?
He never came, my lord. He
Where is your-
submitted the copy of the order, my lord,
Yes.
and then, my lord, he never attended.
Where is that part, that on record? Where is that statement?
I have to get the record for that, my lord, from the.
What is
office.
your version, sir? Whether he
They
ever,
didn't allow me to work, your lordship.
so he never worked, that is what it is.
Yes, your lordship.
So he did not work, so no pay for no work.
But your lordship, the order was rightly passed when they given me the back wages, because at that point of time, I was unemployed. I was not. in
Back
any job.
wages, there is no order of back wages.
Yes, your lordship.
Read. Where is the order of back wages? It is for future wages,
Yes, your
for your tenure from 17/3/17 onwards. The court has said only 50%.
50% of the back.
So you, not back wages.
It's there, page 33. your
What is the
lordship.
date of the order? Yeah, acha, it's order is of 20th
Order
December.
20,
Yes.
2017.
But the issue would be, gentlemen, whether you have worked for that period or not.
No, your lordship. They
Then
didn't
you have
allow
not
me to-
worked. You should have made a statement in the court that I was not allowed to join. Where is your statement? Let us see.
No, I had not filed an affidavit, your lordship.
Then,
The only thing
then it is
that they
presumed
allowed me-
that what he says is correct.
Yes,
You yourself admit that you never worked
yes, your lordship.
on the premise that they did not allow, whereas your conduct is that despite getting a stay, you never reported earlier also.
Mm.
So your propensity to remain absent is fortified. You don't get anything, sir.
But
Okay.
back wages, your lordship, as this order has been passed
Back
rightly.
wages for what
50% of-
reason? For not having worked.
No, because they didn't allow me to work.
Gentlemen, where is that statement again?
Yeah, I
The things boil down to the same position. The appeal allowed. All right.
Deeply
Deeply obliged, your lordship.
Item number 42 and 43.
Please, your lordship. Let's see, in this matter, we paid for some exorbitant mile on my senior age out of station, lordship.
Actually, this matter is some constitutional point is involved here. Constitutional point is involved here. Because whether 2013 Act, I have.
Try to
gone it.
understand, we'll
I-
try to understand, Mr. Das, to best of our ability.
No, your lordship is so experienced, my lord. Why not? I'll give a note to your lordship.
Just tell us,
Yes, definitely.
otherwise also Mr. Nair is not here.
Uh,
So just give us
Yes.
a brief outline.
No, my lord, it will be better if your lordship takes a note, my lord.
We'll
Just
take a
a
note, just give
Yes.
us a brief. What is the constitutional issue in order?
Constitutional issue is 371G, my lord. 371G, which was brought by the 1987 amendment. Special status has been given to Mizoram by way of 371G on certain subject has been given. So one of the subject is or transfer of
And
land, my lord.
Right.
So transfer of land, which is special status and given by virtue of 371G. Now certain lands has been acquired.
Acquired by
So
the
acquired,
UNFBD.
yes, by now, my lord, the went to the learned single, they said they are entitled to get a compensation under 2013 Act. Because it was 1894 Act was followed. So thereafter, my lord, that act remained repealed. A new act 2013 came into force. Now,
When was
what
the
the,
acquisition?
yes, now the learned single judge, we took a point that 371G special status has given to Mizoram. Now, ownership and transfer of land is like is also like an acquisition. Acquisition also is a transfer.
We understand.
Yes,
Just a basic question.
yes.
When was the acquisition made?
I'm sorry.
When was the acquisition made?
Acquisition made.
2014.
Yes.
So why the act of 2013 will not apply?
No.
Is there an exclusion?
Yes, that's why.
brought in an act.
We brought an act, Mizoram, this Land Acquisition Act in 2016. We brought an act,
16.
2016.
But this acquisition is of 2014, Mr.
But
Das.
you see, that's the point which we raised before the learned single judge. 2013 Act, my lord, 2016 we brought the act. In between that, my lord, 1894 gets repealed.
2012.
Notification, which was 2012, my lord will kindly see. Kindly see for a moment a list, my lord. Kindly see the list.
Yes.
Note on proposition, my lord, will kindly see. The respondent by way of writ petition 20 of 2014, petition has essentially sought implementation of the right to fair compensation and so. They say 2013 in respect of land acquisition proceeding initiate pursuant to notification dated 5/7/2012 under section 4 of the Land Acquisition Act. Number 2, in the writ petition, there was no challenge to the Mizoram Land Acquisition Reception and Rehabilitation Act
What
2016.
is the date of the notification, sir? Final notification of the land acquisition.
Land acquisition.
What is the date of that
Yes.
notification?
My act, your lordship, or did
Notification of acquisition.
5/7/2012. I have given a list of dates. Kindly see important dates. 1966, the
That
land
is
of
four-
respondent.
That is the notification under section 4.
Yes.
Where is the final notification?
So it was not completed.
No, it was not completed.
It has not been
Yes,
completed.
not completed.
Then,
Acquisition
but
was.
the allegation is that you are possessing their land since 1966.
Yes.
So the direction which they sought is acquire the land under the new act.
We like were under 2016.
So we acquired on land under 2016 Act.
They have said that no, it
So-
were under 13.
So they said that, yes.
It is stated that senior counsel, Mr. P. Dina, leading the matter on behalf of the respondents is not available today. Re-notify the matters for hearing at top of the list on 12th September.
Well, your lordship can keep this list of dates.
No, you keep it.
I will
with
keep
us. Pass it on.
My lord, may I pray for any day after 12th?
12th September.
Yes, because we have already. fixed.
September, August, no, September, September. I explained to you, it is made. All of adjustment.
Or 14th September then.
14 September.
Yes, sir, objection.
Yesterday, I had opened the file of 2018. Deeply.
Item number 44.
What has happened, Mr. Chaudhary? Something has. No. Anything?
Lordship, in fact, I had filed my LFA.
Yeah, Lordship. When did you file it? That was in May. May 23.
It was, yes.
Well, petitioner is not there. The petitioner in person is not available. List on 29th September. Petitioner who appears in person is not available either. Or to VC.
Daily list for hearing, item 23 and 24.
Yes.
May it please the Lord.
My lord, the petitioner, appellant before your lordships, my lord. He is aggrieved by the impugned judgment of the learned single judge. Now, if a lordship would kindly come to page number, my lord, 98.
You're reading from the judgment?
No, my lord, the order which was impugned before the learned single judge.
98. Yes.
24th of June 2016. Peruse the petition submitted by Rabiul Haq, Assistant Environment Scientist, dated so-and-so, wherein Rabiul Haq prayed for redressal of his grievance in regard to his promotion to the higher post. Thoroughly examine the records relating to promotion of Rabiul Haq, White Board's meeting and resolution, Pollution Control Board, Assam Employees Service Regulation 2012. After examination of all the relevant records, files in connection with the matter of promotion of Rabiul Haq, the following are emerged. Rabiul Haq AES, that is Assistant Environmental Scientist, was debarred from promotion for no fault of his own. No decision was taken by the board in its 94th board meeting for amendment of Table 3, Annexure 3.
Ma'am, before we proceed, contesting parties only the board or the respondent number 5 also?
Right, no, my learned friend appears for
Or a
the,
respondent, petitioner respondent, my lord.
Hiten Sharma.
yes,
my lord. And
yes,
Manoj
Hiten
Purva.
Sharma and Manoj
Manoj-
Borwa. There are two appeals, my lord.
All right.
Ah.
But would his presence be sufficient? The board is not
Board
supposed
is also
to.
required.
Board is required, board is otherwise supporting our case, my lord.
Where are the council, standing council for the board?
I said, do. I've sent for him. my lord.
Please. Let it there. Yes, please carry on.
No decision was taken by the board in its 94th board meeting for amendment of Table 3, Annexure 3, Column 9, Serial 4 and 5, and thus issuance of corrigendum was to deprive Rabiul Haq only as it appears. Action taken by the then authority was not in conformity with the above mentioned service regulation, that is 9(3) and 4 and C. Due to the aforesaid reason, Muhammad Rabiul Haq is hereby allowed for upgradation and promotion with retrospective effect as follows. From Assistant Environmental Scientist to Environmental Scientist with effect from 30th July 2013. From Environmental Scientist to Assistant Executive Environmental Scientist with effect from 1st of January 2014.
Now, a small question. Does the chairman have the jurisdiction to pass such an order?
Yes. Under the water rules 22, he has mine. Anyway, I'll come to that.
Rules
Yes.
22
Rule 22 of the rules.
of this.
Yes.
All right.
Yes.
Next.
Let me place the facts, my lord. I'll come to legal position.
Yes.
Yes. Now, my lord,
Can we have a look at the reasoning assigning the order?
yes,
Or you want to proceed differently?
yes. Now, my lord, before I take your lordships to the, my lord, findings, if the lordships permit me to place the rule, my lord, then it will become easier.
Definitely.
Yes. এখন কুইটা ফোন দিয়া এখন এখন
Are they annexed?
No, I'm giving. দুখন দিয়া কোনটো দুখন দিয়া ৰাফখনো দিয়া এখনো দিয়া দুখন দিয়া দিয়া সেইখন দিয়াচোন দিয়া দিয়া দি এখন দি ৰাস্তাত নাই তোৰ পৰা ভেৰি পেলাব My lord will kindly come to page 8, my lord. Rule 9, recruitment and promotion. Please come to the next page 9, my lord, Roman 3, capital, towards the bottom. Qualification, experience and promotion of employees of laboratory and science service. For recruitment to the cadre of environmental scientists, the minimum qualification shall be master's degree in chemical
biological, life or environmental sciences from any Indian or foreign university or institution recognized by Government of India.
Yes.
Then my lord will kindly come to next page, C. All those assistant environmental scientists of the board who possesses the minimum educational qualification for ES, that is environmental scientist, as stipulated in clause A above, or have completed a minimum of 5 years of service in the board of assistant environmental scientist or chemist shall be brought under category of ES along with the post, provided they acquire postgraduate qualification within 5 years of their service in discipline stated in clause A above. So I'm reading it once again, my lord. All those AES of the board who possess minimum educational qualification for ES as stipulated in clause A or have completed 5 years of service in the board shall be brought under the category of ES along with the post, provided they acquire the postgraduate qualification within 5 years. My lord, otherwise qualification is postgraduate, but if somebody has the qualifying service and within 5 years of service he acquired the degree, then he will be upgraded along with the post. Then my lord will kindly come to page number 34, my lord. This is, my lord, appendix 3.
Yes.
Please come to serial number 6, environmental scientist. Kindly see, my lord, MSc in chemical, biological, life, environmental science. Do. So for my lord, environmental scientist, the requirement is educational qualification is post-graduation. MSc. MSc in chemistry, chemical,
Where are the disciplines mentioned?
yes. On top, my lord. Against one, MSc in chemical, biological, life, environmental science.
Against what? Do. So same
Same.
qualification.
Yes. Then now my lord will kindly come to column number 9. Before that, please come to the remarks against serial number 4. For promotee scientist, the qualification shall be BSc only. So naturally, my lord, for promotees,
Where are you reading this
at
from?
last column, my lord, remark, column number 9.
Yes. Against which post?
Qua serial number 4, my lord, executive environmental
environmental
scientist. Has your lordship got it, my lord?
Yes, we have it.
Serial number 4 on the column number 2. Executive environmental scientist. For promotee scientist, the qualification shall be BSc only.
Didn't see reading. Found it.
My lord will kindly read that. There are given 2, my lord.
Why is the difference?
The difference is, my lord, in the draft, it was not there. My lord, then a board is always admitted that, my lord.
Draft this.
I'm presently I'm trying to draw your lordship's attention.
The
to the
remarks were not
approved
there.
one. Approved one.
Approved. All right.
Yes, Pollution Control Board Assam. Please come to page 34.
Yes. That is why the confusion. What you were reading was not there in the draft, in this document.
So
Yes.
serial number 6, my lord. The educational qualification is MSc in chemical, biological, life,
I
environmental
think
science.
the counsel for the board here. You are there for the board? You're prepared? Are you ready with the brief, gentlemen?
Yes.
All right, that's fine then. Okay.
Then my lord will kindly come to a remark against column number 6. Since it is due, so it has to be read as for promotee scientist, the qualification shall be BSc only.
But do is not there in column number 6, sir.
No, it is there, my lord.
No, there's only a dotted line.
Whatever it is, my lord.
Do wherever they intended, they have return do.
Then, my lord, all the more good, my lord.
Hmm.
Then the purpose for which I am arguing, then the view lordship has taken, that is all the more good
Just
for
we are-
me, my lord. Yes,
There's no question of taking the view.
Yes.
It's not there, it's not there.
yes. So then, my
So-
lord, MSc is the requirement.
Direct recruitment of MSc or promotion from AES.
Yes, yes,
Right.
yes.
Uh.
Now, my lord, what the midship they have done is, please come to the draft now,
Hmm.
that final draft.
Hmm.
At appendix 3.
Hmm. So this, finally, this has been approved,
Yes,
this 2013.
yes.
And what they have done in this?
Now, here, my lord, final draft, there is it doesn't say that regarding that promotee part. Nowhere it is mentioned, my lord.
Only direct recruitment.
Yes.
No, promotion is there now.
No, my lord, that for promotee engineers, the
quali-
BSc will
BSc.
be the qualification, it is not
So
there.
what they construe it to be? What they construe the qualification to be?
Yes.
They are asking what they are saying, what should be the qualification as?
According to them, my lord,
Hmm.
one who is promoted from assistant environmental scientist,
Hmm.
he need not be necessarily postgraduate,
Hmm.
which is not correct, because in the final draft also it was not there. Where from that gap, again, serial number 4 and 5, they have indicated, my lord.
Hmm.
If your lordships kindly
But
compare.
we see the final draft, Mr. Chaudhary.
Ah,
The direct recruitees would require MSc
yes,
for serial number 6. But the AES, just experience of 10
no,
years.
my lord.
Where do you get the minimum qualification here from?
No, my
For
lord,
the
what-
persons having experience
Yeah.
on the post of AES,
Yes,
they would not require MSc. Apparently, that is the intention.
no, they will have required within 5 years. That's C, my lord, 9C.
So that will be come in picture after being promoted.
Yes,
Then, right?
yes.
Hmm.
So there, now this is the position, my lord.
Hmm.
Now, my lord will kindly come to the pleadings part.
Hmm.
They filed the writ petition, my lord. Let us see what was the case projected.
They means
The respondents, private respondents.
you were promoted.
No, I was not
Like,
promoted.
why did they-
That order was interfered by the learned single judge. The
this
order
office
at
order?
page 98
All right.
has been interfered by the learned single.
On their, at their
At
instance.
their instance, my lord.
Right.
Yes.
Okay.
My lord
Okay.
will kindly come to the writ petition, which is starts from page 19.
Hmm. Hmm. Yes.
Please come to paragraph, page 24, my lord.
Writ petition is not at page 90, sir.
Sorry, my lord, page 24. It starts
24.
at page 19,
19.
1.
Okay. Yes.
Page 24.
Hmm.
That adverting to the facts of the case, it is stated that the petitioner is a holder of MSc degree in ecology and environmental science.
Hmm.
It is stated that both the petitioner and the private respondent number 5 are members of the Laboratory and Scientific Service in Pollution Control Board, Assam. Petitioner came to be appointed as scientific assistant along with 3 others in the Pollution Control Board, Assam, White Common Office Order dated so-and-so, issued under the hand of the member secretary, Pollution Control Board, Assam, in the pay scale of so-and-so, etc., etc. By the said office order, the petitioner was asked to report for duty as scientific assistant to the board analyst in Central Laboratory of the board, pursuant to the said matter. Actually, my lord, he obtained his so-called MSc degree from, my lord, by a distance mode.
That is not the matter.
No, my lord.
See here.
No,
Basically, they are saying that your promotion is bad and they should have been promoted.
yes,
That is what they case. All right. That-
yes, yes.
What do they say against your promotion? What is wrong in the order as per them?
Not, according to them, it could be nothing, my lord. But other than seniority aspect,
What is the pleading, please?
yes.
Where is the precise
Seniority.
challenge laid to the order?
No, my lord, they speak of only seniority.
That they are senior to you in
Yes,
service?
yes, yes.
And then why should that not be considered to be a valid ground?
No, they are not qualified, my lord. They do not have postgraduate.
They
Both
are
of
having
them.
MSc. They
No,
are
my
having
lord.
MSc.
They are Mr. Manoj Board do not have. Now, my lord, kindly see the stand of the board. Qua the writ petition,
But let
kindly
just
see.
let Mr. Chaudhary, while we are on the pleadings of the writ petition,
Yes.
what is their challenge, precise challenge to the impugn order? Ground of challenge.
based on seniority.
Read, please.
Yes, I'm reading, my lord. My lord will kindly come to page para 22 at page 36. That it is stated that after promotion of the petitioner to the post of environmental scientist on 37/13, chairman of the Pollution Control Board passed an office order dated 23/9/13, whereby altogether 7 number of post of assistant environmental scientist were upgraded to the post of environmental scientist with immediate effect, subject to the approval of the board.
Yes.
It was mentioned in the office order that consequent to such upgradation, 7 number of incumbents, including respondent number 5, who was then holding the post of assistant environmental scientist, were upgraded to the post of environmental scientist. It is further mentioned that pay and other promotional benefits would accrue to them with retrospective effect only after approval of upgradation by the Pollution Control Board. Assam meaning thereby, till the date of approval by the Pollution Control Board Assam, the said order of upgradation from the post of assistant environmental scientist to the post of the environmental scientist would have no force until and unless said upgradation was approved by
Yes.
Pollution
Now
Control
let
Board Assam.
let us see the requirement of approval.
Yes,
Where is that requirement? The prime facie it doesn't appear that the chairman alone can have that role.
it is
Okay.
there, my lord.
Let us see.
If your lordship would kindly have the Water Prevention and Control of Pollution Assam Rules 1977. Yes. Yeah. I'm sorry, my lord, we have got one book.
No, it's okay, we'll share.
Yes.
Don't worry. Let's see. Yes.
My lord will kindly come to page 7, Rule 22.
Mm.
The chairman shall have the overall control over the functions and activities of the board. Chairman may, etc. My lord will kindly come to Roman 3. Subject to rules, if any, made under subsection 3 of section 12, the chairman shall have full powers in matters of appointment, promotion, confirmation, transfer, disciplinary proceeding, and termination of service of officers and employees of the board.
Right.
So this is the power in my
What are
hands.
the powers of the board?
Yes.
What are the-
Chairman is the, my lord, the head of the board, my
What
lord.
are the powers of the board? sir?
Yes.
Chairman is simply a person.
Yes.
The institute
Please come
established-
to Rule 25, my lord.
Hmm.
Power of the board to go there. Hmm? About the even-
25 is under section 17.
Yes, my lord.
No, that is for a different purpose.
That 25 is for different purpose. my lord.
That is for grant of
Yes,
consent.
yes.
Is there any provision which requires the order of the chairman to be confirmed or approved by the board?
My lord, under this regulation, chairman is not the appellate authority for the decision of the board as per the regulations, my lord. And the provision, rule 20, my lord, the 22(3), that is subject to rule. If lordship
Yes,
takes
yes.
up the AR Act, my lord,
Hmm.
the parent act, my lord.
Parent act. Subject to rules.
They are water. My lord, lordship will kindly come to section 12, my lord, of the AR Act, my lord,
Yes.
Water Act. Water Prevention and Control of Pollution Act 1974.
What does it read?
May I read, my lord?
Hmm.
My lord, section 3A.
Hmm.
The method of recruitment and terms and conditions of service, including the scales of pay of the officers other than the member secretary and other employees of the central board or a state board shall be as such as may be determined by regulation by the central board as the case may be by the state board. My lord, this regulation was exercised, was framed in exercise of this power, my lord. Once these regulations has been framed, any provision contained in the rule will cease to have any force, and the service conditions will be governed by these regulations only, my lord. Regulation. That is the, my lord, Pollution Control Board, Assam Employee Service Regulation 2012.
Okay.
Well, it was adopted by the state government on 24th of February 2014, my lord. So it came into force immediately thereafter. By notification on 26th, it came into force, my lord. Therefore, any provision contained after coming into force of this regulation in the rules will cease to have any effect so far appointment and promotion is concerned, my lord. And my lord, what was challenged, my lord? I was the writ petitioner. Lordship, may kindly turn to page.
Just hold on, no, let Mr. Chaudhary
My lord.
conclude. We'll ask later. Yes.
Yes. So let me read that pleadings, my lord. Yes.
And this question, Mr. Chaudhary, you will have to answer that once the regulations have been adopted, what is the role of the rules?
My lord, we did not go to all these things. Let my learned friend satisfy that they fulfill the qualification criteria as per 9. If
All
they
right.
do not fulfill, my lord, then they
Right.
do not have locus to challenge my promotion.
Whether you have raised that objection in your reply, affidavit in opposition?
Yes. My lord, not to speak of anything else, let me, my lord, place 2-3 paragraphs from the board's affidavit, then it will be very clear.
Yeah, right.
Please come to my lord, page 125.
Mm.
That's the affidavit filed by the board.
Yes.
Para 4 at page 127.
Mm.
That as regards to the statement made in para 3 of the writ petition, the answering deponent begs to state that the petitioner acquired MSc in Ecology and Environmental Distance without availing NOC from the Pollution Control Board, which is in violation of the law of the land, including provisions of the Assam Civil Service Conduct Rule. The eligibility criteria for admission.
He has not been ousted for this reason.
My lord,
He has not been deprived of promotion for this reason. That is not the reason in the order.
yes.
No.
No, what I'm saying is, my lord, by making this argument, what I'm trying to show, my lord,
Mm.
there could not have been an agree person for my promotion. For that, I'm making this submission, my lord.
Mm.
The eligibility criteria for admission into the said course is graduate in any discipline, BA, BSc, BCom, LLB, and without any practical subject in that course. Whereas Rabiul Haq, that is respondent number 5, obtained MSc in BSc in chemistry and MSc in environmental management under Guwahati University. It may be stated here that the petitioner was appointed against a purely temporary post of scientific assistant by order dated 31/12/94. On the other hand, the post of scientific assistant is related to laboratory and scientific service of the board. And for such service, chemistry as a subject is essential for performing such duty. Despite of having BSc degree without chemistry, the petitioner was appointed to that post. Although Mohammad Rabiul Haq was having BSc major in chemistry degree, but then authority of the board did not consider respondent number 5 in spite of
There
having.
is a fundamental issue involved in it. Whether the chairman can go above the resolution of the board. Would that not amount to an impropriety in exercise of power?
No, my lord, I would humbly submit, my lord. Why they are not considering my case?
That is a different thing. The matter could have been remanded on your request. You could have come in red saying that the board was not justified in.
I filed a representation, my lord.
The fundamental question is they have challenged that order of the chairman. What does the chairman have power to overrule the recommendation of the board? The resolution of the board which has been approved by the state government.
No, my lord.
Yes. Does it talk of it? Does the order talk of setting aside or overruling the board's resolution?
No.
Then the order is bad on the face of the record.
Lordship will, all right. Lordship will kindly permit me to place 2-3 paragraphs from this.
Yes.
Then my lord will kindly come to para 15.
At best, the matter should have been remanded to the board to reconsider.
Yes.
That was the only answer.
That should be done,
Because
my
the
lord.
chairman didn't have the power to overrule the resolution of the board. You can't even argue that.
Yes. My lord will kindly come to page 133.
Yes. All right.
That as regards the statement made in paragraph 23 and 24 of the writ petition, The answering deponent begs to state, petitioner along with two other had to complete master's degree in chemical, biological, so and so from any Indian or foreign.
This is,
university.
Mr. Chaudhary, this affidavit is just mudslinging by the subsequent authority on the previous authority.
No, my lord. One aspect is very important,
Does
that
this-
you're kindly come to the subpara. This is very important, my lord.
Yes.
It may also be pointed out here that a corrigendum was issued on 1/8/13 by the then authority to legalize the promotion of the petitioner along with two others to the post of assistant environmental, executive environmental scientist,
Whether the,
that too without amending the relevant provisions.
Ms. Chaudhary, whether the chairman had the power to rectify that error, if at all. That is the fundamental question before us.
No, my lord.
That will create chaos in the system.
No, my
If
lord.
the chairman goes on overruling the board's decision, that is permissible.
No, my lord, the board never took any decision to amend the regulation which they are purporting to act on that. I'm on that, my lord. Lord will kindly appreciate that. My lord, when it's-
Final resolution that is there.
Ah.
So final resolution, whether by passing that order, the chairman could have nullified the resolution of the board, sir. That is the direct effect. The best way out to our opinion is to remand the matter to the board to undertake a fresh exercise.
Huh.
Considering all cases of all.
Huh.
What do you say?
and including the recruitment rule.
Everything. Recruitment will not make a comment.
Yes, yes.
We will not make a comment on that. As per the rules,
Huh.
prevailing rules,
Yes,
let them hold a fresh exercise.
yes.
Lordship definitely, Lordship kindly come, hear me for 2 minutes, my lord.
Yeah, we'll hear you, of course.
But what was challenge in the writ petition, my lord? Is page 98 of the appeal memo, my lord. Lordship, I'll take your lordship to page 98 once again, my lord. The last part. Due to the aforesaid reason, Mohammad Rabiul Haq is hereby allowed for accreditation and promotion with retrospective effect as follows. From assistant environmental scientist to environmental scientist with effect from 30 July 2013. From environmental scientist to assistant executive environmental scientist with effect from 1st January 2014. So he was given retrospective promotion from a date when he was not born in the cadre of, my lord, executive environmental scientist.
Yes, all right.
That is how, my lord, I'll just show it from the date. my lord.
That's what we are saying as council. We'll remand the matter, let the board take a fresh decision,
Yes.
recent decision,
Yes.
after considering the
And
representation.
my lord, the
of all
other
parties.
person, Mr. Manoj Borua, he's a BSc. And he has not acquired the degree also.
Everything will be taken into account.
Yes.
by the board.
In fact, my lord, the petitioner has also filed 2 writ petitions apart from this writ appeal.
Yes.
These issues are also there, my lord. That writ petition is also pending.
Those writ petitions will be closed.
No, that is that is regarding further promotion.
No, my lord, one promotion is. That writ petition has also filed, that is also pending, my lord.
This order will take care of those. writ
Yes,
petitions
yes.
also.
That can be done, my lord, but
Yeah, what do you say? What is your call on that? What is your take on this observation that whether the statement could have overruled the decision of the board? There is virtually amounts to that.
In fact,
The observation in para B,
yes.
no decision was taken by the board in this meeting. Who is the
No,
chairman?
no,
to come?
no, my lord, this is a finding of fact. By this, my lord, by this purported resolution, it was sought to be shown that,
Thus,
my
the
lord,
issuance of corrigendum was to deprive Mohammed Rabiul Haq.
No.
Rabiul Haq should have
no, my
gone
lord, B is a finding of fact, my lord. It is not a,
Chaudhary,
my
that
lord,
is the rank and discipline by the chairman, we'll say. Rank and discipline.
no, with utmost respect, I'll submit, my lord. B is a finding of fact because
Come
board never took any decision to amend.
Come what may, sir. He should have written to the board, please take a fresh decision. He has gone beyond his jurisdiction, absolutely.
my lord, in fact, he was remanded to, he was given promotion. His promotion was not approved by the board. That order, he also, the appellant did not challenge, my lord. Lordship may kindly come to page, my lord, for a second.
It was not approved.
It was not approved, my lord.
Where is that order?
Lordship,
Oh,
I'll
then
come to that.
things
Lordship,
take a
give me
different
second.
My
color.
lord, here is a case, I was the only eligible person,
We
but I was
understand,
not
Mr.
given
Chaudhary,
promotion.
the man should have come in red.
My lord,
He
page-
just managed the things with the chairman.
No, no, my lord.
That's all.
Is too small a fry in the entire organization, my
We
lord.
don't know what
I'm-
happens.
I'm making this statement with all.
Lordship,
He has managed to engage Mr. K. N. Chaudhary.
No,
He
no,
can't be a slow.
no,
small fry, that is
no,
for
my lord,
sure.
nothing like that. My learned friend has requested me.
Members of the
So I am
bar are sitting
appearing.
here. Will they differ from what I?
Lordship, kindly come to page 84 of the appeal memo, my lord.
Yes, let's see that. So now the issue is, both the authorities start excising their jurisdiction.
My lord,
Whose order is to prevail? Yes.
Lordship has got it, my lord. It is on 23rd of September 2013. Subsequent to the subject to approval, this is important, subject to approval of the board, the post of assistant environmental scientist in the board are upgraded to the level of environmental scientist with immediate effect. Consequent to
So
that,
this was the chairman, earlier chairman who was,
Earlier chairman.
chairman.
so he had recommended,
No, my lord.
board did not accept.
My
Where
lord,
is
that is
the-
what I am trying to say. My lord, it was subject to approval. Because
Approval.
board could not have the power of its own.
Yes, chairman does not have
Chairman
power
could
on
not
his
have the power
officer.
of its own.
That
in this, my
apparently it
lord,
doesn't stand to reasoning
My
that
lord,
the,
at serial number 56, Rabiul Haq is there.
My
yes,
lord,
Lordship, may
writ
kindly come to
petition
page-
was filed, my lord. Writ petition was filed, it was withdrawn.
By-
because-
by
because
Rabiul Haq.
Yes, we filed it, withdrew, my lord.
withdrawn without liberty.
Because without, of course, because the assurance was given, we'll consider your case.
we means who? Chairman can't do it, sir.
My lord, that's why I'm not,
And Lordship, may kindly come to for a second, page 90, my lord.
no, my lord, now the
12th
lord-
August.
lordship
12th
is inclined to remand the matter. I have got no problem, my lord. I'm
My lord,
absolutely
Lordship may
agree.
not like to remand the matter. That's why I am
Why?
placing this, my lord.
All right, show us, what is it?
Lordship, page 90, my lord, Lordship has got it.
Hmm.
It is dated 12th of August 2014.
Hmm.
Pursuant to the decision taken in 96th board meeting
Hmm.
under agenda item number 5,
Hmm.
4 posts of assistant environmental scientists are upgraded to the level of environmental scientist.
Hmm.
And the following 4 senior most assistant environmental scientists are allowed to hold the upgraded post of environmental scientist with effect from the date of their joining as shown against their names. The pay and other promotional benefit will accrue to them with effect from the date of their joining as per board's order, my lord, that I have shown to your lordship, my lord.
Hmm.
But lordship, we come to the next last paragraph, my lord. In view of the board's decision as referred under above para, post held by the following personnel shall continue to be the level of assistant environmental scientist. Here, my lord, at serial number 2, Rabiul Haq.
Hmm.
That order was never challenged, my lord.
Never challenged. Even the chairman in the subsequent order doesn't make any comment on that order.
Yes, but
My
that was never challenged. And he continued to be in the post of assistant environmental scientist. How the appellant could have given retrospective promotion to the post of environmental scientist when he was not even born in the cadre. Considering that aspect, my lord, and considering the laws laid down by the Honorable Apex Court on retrospective promotion, the single judge has passed this order, my lord, which requires no interference.
My lord, let my learned friend show to your lordship, this Manoj Borua, for whom they are representing, that he is a postgraduate. My lord, he is not even a postgraduate.
Promotion was never challenged. Who challenged it? Who put it to challenge? You did and you withdrew. Chapter closed. Is it
Kindly
admitted? What
see,
did you-
as if-
Just let us know, where is the earlier order passed in your writ petition? What was the writ petition about?
No, my lord.
Just
those-
hold on, sir.
those are
Please
there.
answer.
What I'm saying is, my lord, those are there. What I'm trying
That
to,
promotion was not, never in challenge. Are you now in co-warranto?
no, I'm not in.
No, then-
co-
then-
Prima facie, my lord, prima facie, he is not a postgraduate.
Surely we are not bothered with it. That order was never challenged. Even your chairman, with whom you manage the things, he even doesn't make any comment on that order. Though he claims to be having that muscle power to overrule the board, but he doesn't make any comment on that. So how his promotion can be put to challenge?
And in fact, in my
By-
recollection-
just hold on. But why you are aggrieved by that order of the chairman?
Yes, mine.
Do you get out of
Because
the picture?
I was otherwise senior, my lord, both the petitioners,
Yes.
on the date of
So-
entry into the
So
service.
he becomes senior to you.
He becomes senior from a date he was not born in the cadre. That is
All
why.
right, all right, all right.
My lord,
Yes.
number one, Hitesh Sharma, the नाम तो book. Hiten Sharma, he do not have chemistry and he joined.
Chaudhary,
I'm just saying
issue is that if you are aggrieved by their promotion, your client was supposed to approach this court and we are told that you filed some petition that was withdrawn. After that, does it lie in your mouth?
No.
Then you manage
Now
with the chairman.
Now the issue is, my lord,
Yes,
what is under challenge is an order whereby benefit was given to me.
yes.
So
So that,
lordship is also of the view that
So,
it is
oh-
not the chairman, then somebody else is. the
let
competent.
the board decide. All right, what
That's
objection
why-
do you
that's
have
why
to that?
lord- That's why
Let the
lordship.
board decide qua his prayer for promotion.
Yes.
Let the board decide.
And my respectful submission is that single judge has already decided the issue. Therefore, no requirement for
No.
further adjudication of the
Or
matter.
there- For that purpose, Ms. Chaudhary, where is that order in the earlier round of litigation?
Court order.
Let us have that.
I'll
Look
have
at
the
that.
copy, my lord.
Let us see. Do you have a copy of the writ petition also? If you have withdrawn that writ petition after giving a challenge, Mr. Chaudhary,
No.
then you are not entitled
No,
to
no,
it.
Lordship will kindly come to page 98 for a moment.
Just for, let us have a look at that order.
Lordship will kindly come to order to assemble.
Yes,
That order is not presently available, my lord.
he is having it.
I'm having that, my lord.
Let's see.
I'll have a look.
That will have a bearing on the entire controversy. You are having a copy of the writ also?
The writ petition with pleadings along with orders, my lord.
Yes, yes, yes.
That, my lord, first, my lord, lordship, prayer for withdrawal was taken.
Ah.
Thereafter, lordship is the petition, my lord. Lordship will come to see the prayer part.
Just hold on. It is stated that the appeal of the petitioner has now been rejected by the appellate authority. Which appellate authority? And where that order was never put to challenge? Let's see the pleadings of the writ petition then.
My lord, that was reverted, was subsequently he filed another writ petition. That order is, my lord, there is no pagination. It was passed by, my lord, this order dated 2/2016. May I read, my lord? It is somewhere in the middle portion, my lord.
Yeah, yes.
Writ petition number 2721 of 2014.
That is, Mr. Hawk submits that instruction on instruction that the case of the petitioner for promotion
Yes, my lord.
is under consideration. Thus he seeks liberty to withdraw the writ petition.
Now, what was the prayer, lordship will kindly see, my lord, at page 11, my lord.
Hmm. Page 11
Yes, my lord. That's
of the
of
first,
that paper.
to quash the promotion of the respondents numbers 4, 5 and 6.
Yes,
You
ma'am.
gave up that promotion
No.
and then by an indirect measure.
What I'm saying is,
Yes.
if your lordship will kindly come to page 98, this was under
Yes,
challenge
yes.
before the learned single judge.
By
Now,
this
lordship
order, by the dint of this order, Mr. Chaudhary, their seniority position is disturbed.
That's what
They are
I'm
not
saying.
heard.
No, that's what I'm saying.
Yes,
So, my lord, number one, perhaps the chairman could not have exercised. And
yes,
number two, natural justice.
yes.
Therefore, lordship will remand the matter.
For what purpose, sir? You have given up the challenge. Mr. Chaudhary, you filed a writ petition challenging their promotion. You have given up that right. You have given up that challenge by withdrawing the writ petition without any liberty at all. Read this,
No,
please.
that I've seen, my lord. That. I think so.
Have a look at this writ petition.
And in fact, my lord, under the regulations, as chairman is also not the appellate authority of the board.
Hey, Roman, there was 6 to withdraw the writ petition. It was challenged and withdrawn.
And then withdrawn, then
That
how
without
could
liberty.
you have got, this is circumventing the process, managing the things through an authority who is not competent.
No, my lord. That could be
And
the
one more
impression,
thing,
but my lord.
one more thing, sir, one more thing, read prayer B of the writ petition. How could you even have been promoted to the post of,
But it is something
Oh,
like
that's
review
just-
DPC.
just read para 5. Your prayer was to be promoted as AES, whereas the chairman state of promotes you as ES,
And my lord, assistant executive and 2 steps ahead, my lord.
2 steps ahead.
And from
Your,
there it
your
was not-
prayer in the writ petition was not even to claim a promotion as ES.
No, what I'm saying is,
Yes.
therefore, lordships will remand the matter.
Why?
But I can
Why
be
not?
remediless. I'm, my lord, I
You-
perceive that I have
We'll
wrong.
give you a liberty to file a fresh representation. Do it. The board will consider it as per law. There's a question of remanding. For remanding, we'll have to interfere in the single bench order, which is not required. In view
No.
of these preceding facts, which you have not
No,
pleaded.
no, my lord will kindly come to.
Have you explained this litigation in your appeal, Mr. Chaudhary? That is the fundamental question now for you to answer.
Even if, my lord, this honorable court division bench has already held, even if 2 views are possible, my lord, in a writ appeal, the views, my lord, adopted by the.
That
Correct,
Mr.
correct.
Chaudhary tells us every day.
No, that is correct. That I am not saying as a proposition, I can say no. But my lord, in these facts, the facts are too glaring.
Mr. Chaudhary, facts were glaring at that stage. You gave up that challenge. Now, by circumventing the process, you managed to get them back
Would
down
you-
in seniority.
Would the lordships give me one opportunity, my lord, regarding the facts, some facts, it appears my learned friend did not brief me, my lord, regarding this withdrawal and all.
Tomorrow. Part heard,
Tomorrow, my
heard in
lord,
part.
Friday, my lord. Friday,
Tomorrow.
tomorrow,
Heard in part, day after tomorrow.
day after.
Heard in part,
Yes, day after.
hearing list for further hearing. Yeah. Give this back. to Prepare a note on this.
Yes,
this
yes,
writ petition.
yes.
I have prepared a synopsis, my lord. if you
Yes,
want to
yes.
please.
Because this writ petition, Mr. Chaudhary, virtually destroys your client's case.
Yes, I
This
follow.
writ petition completely changes the color of the controversy.
I'm going to listen to the rest.
And
Well, should I place the synopsis, my lord, today?
yes, day after tomorrow.
Day after tomorrow. Briefly obliged.
Item
Don't
number,
scold him in the presence of the court, Mr. Chaudhary. Don't scold him in the presence of the court. You will take him out and do that.
item number 25 and 26.
May it please your lordship. In these two writ petitions, basically it's a common judgment of the
Writ
honorable single
appeals.
judge.
Yes.
So what is, I have given a synopsis of list of dates and my submissions, your lordship. I have combined both together, so that on the last occasion, your lordship, I have given that. If I can read that, your lordship, in consonance with the writ appeal, then your lordship, it will be easier for your lordship.
As you desire. Sir. Yes.
There are actually two. Initially, I gave one, which is with regard to one appeal. Now I have given
Oh, you are.
both the
These are
appeals,
both
one,
in relation to appeal number 337.
337.
Yes.
337, but I have also given it the dates of the next writ appeal also together, so that since it's a common judgment for both, that's why I'm giving it together here. But yeah, still not-
What precisely is the controversy?
Basically, your lordship, we are challenging the points.
And just hold on, who are the councils representing? Yes.
My learned friend is for the rubber board
Yes.
and he's for the private respondent.
For the Rabha board,
Rubber board.
rubber board,
Yes.
Rubber board. Lordship.
Union of India,
2, 3 and 4 I mean.
Union of India is not required to be heard.
Basically, the matter relates to rubber board, your lordship. There's a
Alright.
formal party.
Yes,
If your lordship,
very well.
I'll just show what are the grounds of appeal before coming into the facts, so that it will be easier for your lordship. Page 6 of that
Okay,
list of
synopsis.
submission. Then I'll come to the, just my
Which
points
one-
that I'm
which
raising.
one do you want us to pick up? There's one in 8 pages and one in 7 pages.
Lordship,
which
one
one you-
with 8 pages, your lordship.
All right.
That is more comprehensive.
Page 6.
Page 6, grounds and appeal, your lordship.
Hmm.
That these are the grounds I have taken. Then I'll come to the facts and prove that these are the grounds. First is promotion exceeds 50% of the reserved category candidates. Second is clubbing of vacancy of different years together. The zone of consideration has been extended beyond the permissible limit. Persons junior to the appellant in both the appellants, your lordship, promoted prior to the appellant. Seniority list was not maintained legally and persons junior to the appellant made senior in the gradation list. Then, your lordship, what has happened? The honorable single judge did not consider any of the submissions. The challenge, the honorable single judge actually rejected on 3 grounds that I have stated. The challenge was within time and not belated. It has been stated to be belated. First point of the honorable single judge. Then second was the minutes of DPC could not be challenged. The same is an internal document. The court says that since you have not challenged the minutes of the DPC, therefore this appeal, this writ petition does not lie. And third was that, your lordship, the gradation list was prepared prior to the promotions, but there was subsequently no gradation list was promoted. Then 10th is, your lordship, the law relating to backlog vacancies not followed. They have their own OM, which they have not followed. Then lastly, your lordship, this is where a recent judgment was given, a part of this case itself in the single bench. Seniority cannot be fixed in terms of rooster point for appointment who gains simultaneous appointments. So here, your lordship, there are 2 parts in this judgment of the honorable single judge. One is our case was dismissed, and in one of the writ petitions, there are a series of writ petitions. One writ petition was allowed, holding that the person concerned, the private respondent in that writ petition is not entitled to promotion.
Right.
That part we are not challenging, we are challenging this part. That was challenged in a different, your lordship, in a different context. And the honorable single judge held that he is not entitled to, so he has been reverted back to his original posting, so he could not get the seniority. So we are not concerned with that. There's another writ appeal filed by the private person that is pending. There's no stay order. So I'm just making it a fact. So now, your lordship, will kindly take up the facts. I will come to the, just read the first initial parts. These are not, as of now, that are not under challenge. On 15/2/1989, the appellant initially appointed as junior field officer in the labor board. In 1389, Srimati Rashmi Rekha Majumdar. Now, this is the second appellant, Your Lordship, so I am giving it together. Appellant number so and so in writ appeal so and so was appointed as junior field officer. Now, 31/3/1994 gradation list of junior field officer was published. The appellant was at serial number 29. Rashmi Rekha Majumdar was at serial number 31. Respondents number 5, 6, 7, 9, 12 and 13 were at serial number 63, 60, 90, 89, 91, 105, 109 and 125 respectively. The other private respondents were not even included in the list at that point of time. Now, Your Lordship, on 16/4/1996, the appellant Prashanta Borua was promoted to the post of field officer. On 28/5/1996, Rashmi Rekha Majumdar was promoted to the post of field officer. Now, the gradation list for field officer was published 31/12/1998. Gradation list in the cadre of field officer was published. Appellant at serial number 49, Rashmi Rekha Majumdar at serial number 151. None of the private respondents found place in that particular, Your Lordship, gradation list. I will start from here, Your Lordship, page 72.
Prashanta Borua able to?
Prashanta Borua.
They have been promoted presumably by extending benefit of reservation.
Yes, we do not have any issues on that, but you cannot give them the roster point on promotion. That is basically the issue. And clubbing of vacancy, which is absolutely against the rule, and as well as a Supreme Court decisions I have already mentioned, I am providing those. Exactly, they have gone against those. Their own rules and the Supreme Court laid down law.
What do you want?
Now, what has happened, Your Lordship, in this 31/12/1998 is the gradation list.
Page.
Page, Your Lordship, starts from 72
Yes.
in name of both the appellants are at page 77 at serial number 149, Prashanta Borua, and 78, 151, Rashmi Rekha Majumdar. None of the respondents were there at that point of time. So overall, their cadre seniority is there. So I just wanted to point out in this. Now, Your Lordship, what has happened thereafter? Kindly take up the synopsis of list of this. 2/6/2006, again, appellant was promoted to the post of Assistant Development Officer. So Prashanta Borua was promoted to the post of Assistant Development Officer in 2006 itself. And in 31/12/2006, a gradation list for Assistant Development Officer was published. Appellant Prashanta Borua at serial number 113. None of the respondents found place. Obviously, they are not even there in the earlier cadre. How they will be in this cadre? None of the respondents found place. The gradation list of the field officer was also published on the same day. There, Your Lordship, Rashmi Rekha Majumdar now has become senior, one of the senior most, and she is at serial number 3 in the seniority list, Your Lordship. That, Your Lordship, will find at page 85. I'll just read. These are the facts. Your Lordship. Till here, nothing has happened, no problems, Your Lordship. Now, Your Lordship, serial number 9. This is important because here from the law point starts. The respondent authorities did not hold any DPC in the year 2006, 2007, 2008. Although there were 6 posts, number of vacancies during this period in the cadre of ADO, Assistant Development Officer. Now in 10. In the year 2009, 20 vacancies occurred in the cadre of Assistant Development Officer. Serial number 11, Your Lord. Now, DPC for the promotion to the cadre was.
These vacancies would be relevant only for the appellant Rashmi Rekha, because the other man has already been promoted.
He's been promoted. Yes.
Yes.
This is with regard to the second part. So what has happened? Now, DPC for the promotion of the cadre of ADO was held in 2009, clubbing the vacancies of year 2006 to 2009, which come to 26. Now, this is absolutely illegal. This is not, Your Lordship, allowed by law. I'll come to the provisions, their rules, as well as the judgments a bit later. First, let me put, because they are doing it twice. Now, Your Lordship, on serial number 12, the 4/12/2009, the order of promotion for these 26 vacancies from the period from 2006 to 2009 were given. The private respondents have been placed and blocked over Rashmi Rekha Majumdar, who is senior to the private respondents in the cadre of FO, which is the feeder cadre. The appellant was already promoted prior to the present promotion. That is, your lordship
This,
has already.
this order of
No
promotion,
gradation list was published
Mr.
after
Manan,
this promotion.
this order of promotion of 412(9) was not challenged anywhere.
This is challenged. This has been challenged.
Challenged in which proceeding?
Yes.
In which proceeding?
Yes, this proceeding, there is a series of many
When-
cases are there in the writ petitions. One of the writ petitions challenged this one.
This,
Now
Writ
your
peti-
lordship will kindly turn to page serial number 13.
Mr. Manan, just hold on.
Yes,
The gradation list was, the promotion list was issued in 2009.
yes.
When was it challenged?
It was challenged in 2014,
16.
14.
All right. Yes.
After the next promotion, because at that time gradation list was not published.
Hmm.
So then now nobody knows where they
You
People are
mentioned that the private respondents were placed en bloc.
en bloc. That is what I would like to show that your
But
lordship,
you did not raise any grievance against that.
that has been raised in that writ petition.
5 years later.
Yes,
All right.
that is at page 94, your lordship will kindly see.
Yes, all right, carry on, carry on.
Then your lordship, serial number 13. 20 fresh vacancies of 2009, only 10 posts can be filled up by reservation, considering from the 6 vacancies of 2006 to 8, 3 posts can only be filled up by reservation, and the remaining 13 posts should go to the general category. In the instant case, what they have done, 19 reserved category candidates were promoted, which is against the settled position of law. And no distinct group for reserved category candidates as part their OM has been made. That also I'll come to the OM later on. I'll just give the facts of the matter. 14-year-old, 19/10/2009 DPC proceedings indicates Rashmi Rekha Majumdar at serial number 2 and the private respondents come down below at serial number 47 onwards. And in the extended zone of consideration in order of seniority for promotion. This, an additional affidavit has been filed. I have annexed that particular promotion orders. Serial 15. Now again, the second part, your lordship. If clubbing of vacancy is not done, the zone of consideration would be less, considering the 20 fresh vacancies of 2009. The extended zone of consideration would be 20 into 5 is equal to 100. So they went beyond 125. 6/1/2006, your lordship, the extended zone of consideration guidelines promoted by an office memorandum 6/1/2006. I'll also go to that later. Now, 17, your lordship, even if clubbing of vacancies are considered, the extended zone would have been 26 into 5 is equal to 130. Therefore, persons at serial number 139, 146, 156, 157 of the gradation list of FO would not have been promoted and put at serial number 19, 6, 11, and 15 of the promotion order dated 4/12/2009. And that too above Rashmi Rekha Majumdar, who is senior in the feeder cadre. Now, your lordship, this is from where both the petitioners have come. Number 18. Your lordship. In 2014, again, DPC was held 6 vacancies for the year 2012, 12 vacancies for the year 2013, 6 vacancies for the year 2014, clubbing together, and 24 vacancies were filled up for the post of development officer, DO. Here the issue starts, basically. 12/8/2014, promotion to the post of development officer was issued from the post of ADO. As there was no gradation list after 2006 in the cadre of ADO, the appellant Prashanta Borua as well as Rashmi Rekha Majumdar was not promoted, and the private respondents were promoted were much junior to both the appellants. Prashanta Borua was promoted much earlier, but in the next promotion, he was not even promoted. These persons who were at serial number 145 were promoted. Now, 20, your lordship. The office memorandum, this part, your lordship, has already been decided by the honorable sir. The office memorandum promoting D. Suresh as ADO without any DPC, his promotion was set aside by the honorable single judge by the order. So he has set aside. I am not aggrieved by that. 31/12/2021. The gradation list was published then, your lordship, after 2006 of development officer was published, wherein the appellant is at serial number 24, Rashmi Rekha Majumdar at serial number 35, respondent number 7 and respondent number 13 were placed at serial number 1 and 2 respectively. This is in the additional affidavit. Therefore, persons much junior to the appellant as well as Rashmi Rekha Majumdar have superseded them. The Now, the second part, your lordship, the order was passed by the Honorable Single Judge on 23/3/2021. The order of the Honorable Single Judge did not consider the issues that was raised before the Honorable Judge. The Honorable Judge held that the minutes of the DPC, having not been challenged, the relief paid cannot be considered. The Honorable Single Judge held that the challenge to the promotions being stale could not be assailed. This is stale, your lordship, not stale. The Honorable Court held that the writ petition suffers from non-joinder of necessary party. These are the three counts on which it was. Non-joinder of parties, why, your lordship? Because I have already made those persons who have superseded me as respondents, your lordship. The court held that those persons who are junior to me, it's a same reaction, they will be affected, so everyone should be made a part. On that ground, it was, these are the three counts on which it was challenged. Now, there is the next two, your lordship, is relevant to some certain point, your lordship. These are the two judgments of the Honorable Kerala High Court. On this rubber board also has their office in Kerala head office. So the judgment with regard to similar type of a judgment with regard to seniority was also held at that point of time, taken up by the Honorable Single Judge in Kerala High Court, who held that the feeder seniority has to be maintained. So that there was a review petition filed, there was a subsequent draft regulation. So court at that point held that the draft regulation should be applied, but in the review, court said the draft regulation cannot be applied, but the seniority in the feeder cadre should. So these are the basic facts. Now I will come to first point with regard to the clubbing, which your lordship comes, the OM with regard to the clubbing of vacancies that your lordship will find at page 173. Clubbing the conclusion. Clubbing of vacancy. Clubbing of vacancy. Just a moment, your lord. OM. Clubbing of vacancy to OM. There are actually, we have annexed many OMs, your lord. So that is, your lordship will find at page 181. I will take your lordship to page 183. 182, 2.4.1. Where for reasons beyond control, the DPC could not be held in an year, even though the vacancies arose during that year or years. The first DPC that meets thereafter should follow the following procedure. 1. Determine the actual number of regular vacancies that arose in each of the previous years immediately preceding, and the actual number of regular vacancies proposed to be filled in the current year separately. Consider in respect of each of the years those officers only who would be within the fill-up choice with reference to the vacancies of each year, starting with the earliest year onward. And number 3, prepare a select list by placing the select list of the earlier year above the one for the next year and so on. So this was not. They clubbed it together twice, in 2009 as well as in 2014. So therefore, that reason, the extended zone of consideration was very high. And we were superseded by this. So this was absolutely clubbing, it's incorrect. In this regard, your lordship, I have 3 judgments which I placed. These
First,
judgments,
tell us
your
how
lordship,
the single bench has dealt with this argument. Then we'll come to the judgment.
single bench has not taken consideration.
Not considered.
No. These
These were
3
grounds.
points, which clubbing of vacancies, reservation.
These were grounds taken in the writ petition.
Yes, these are the grounds taken in the.
Let us
These
see.
are the case only. Clubbing,
Let us see the grounds
yes.
in your pleadings.
Writ petition, your lordship, starts from page 31. Hence, actually page, effectively it starts from page these parts, your lordship, basically. In fact, the memorandum has also been annexed there. From para 8 onwards, your lordship, all these has been stated. And judgments are also being placed along with the writ petition.
Read the grounds, specific ground. What you are arguing, there is that specific ground pleaded.
Yes, just a minute, Mr. Even calculations are given. Yes, okay. One. Deputy in reply, but we see to para. 143. Punto. Clubbing. So in the affidavit, your lordship, we have annexed, specifically the calculations have also been given. It starts from page 140.
Reading was required to be there in your writ petition.
It should have been, but
So read, you are making aspersions that the learned single bench did not consider
this
these
was all,
specifically grounds.
yes,
Where have you raised these grounds, sir?
these grounds are already there before the honorable judge on record in the affidavit.
Whose affidavit?
The 140, page 140,
Whose affidavit?
our affidavit.
But then why didn't you plead so in writ petition? You make out the ground in the rejoinder affidavit, not in the main pleadings.
Not in the main writ petition, these are
Yeah.
brought in the next, in the rejoinder affidavit.
You have to amend the writ petition then.
The writ petition was basically was with regard to excess of 50% vacancy, 50% quota. The other point, clubbing was basically in this specific,
Never period, gentlemen.
yes.
They were never period. So why the learned single judge was supposed to apply mine to these arguments?
Because your lordship has para 6, page 144. So that was there. It was, the arguments were made.
Amend the writ petition then. You could not have created grounds in the rejoinder.
But
What
your
was not
lordship,
pleaded in the original petition, could it have been brought by the way of a rejoinder?
so lordship, if it is brought in a rejoinder, the court will not go ahead with on that.
We can plead that this
No,
was
we
not,
have- we
not a
have-
basic fundamental. ground.
raised
All
this-
right, read the argument. Where did you make this argument? Read the judgment.
Judgment, your lordship will find
Yes. Para number.
page 100 and it starts from 123 and the judgment starts from 130. So your lordship will, first two paragraphs I am not reading. 3. The
Paragraph
case
five.
projected in the writ petition is that the petitioners were appointed as field officer at various point of time, and they have become eligible for promotion to the next higher graded assistant development. In short, the private respondents and the others who were junior to the petitioners were promoted and en bloc placed over the petitioner. Accordingly, it is projected the petitioners were deprived of being considered for promotion to the post of development officer from the post of ADO. It is projected that respondent number 1 as an employer published the gradation list of employees on 31/3/94 and 31/12/98. Thereafter, the gradation list of employees was published on 31/12/2006. It is submitted that between 98 and 2006, no gradation list was published. The grievance of the petitioner is that The respondent authorities did not convene any DPC meeting from June 2006 to November 2009. This has been specifically stated. And during the period, 26 vacancies arose in the rank of ADO, referring to the statement made in affidavit in reply. Court has referred, your lordship. In writ petition so and so, it is projected that in the year 2012, 6 vacancies were fixed. In the year 13, 12 vacancies, and in total, there were.
What happened in writ petition? number
Grievance of
58?
the petitioner is according to the relevant circular department training so and so, bearing the DPC is required to consider EOS vacancies. This was stated, your lordship.
What happened to writ petition number 5815/14?
These are all taken together, your lordship. All these writ petitions, your lordship, page 130 onward, 23 onwards. This writ petition number 5815. 5815 is at page 124. Prashanta Borua and Pratip Kumar Goswami has retired, your lordship, so he has not come before your lordship. These are the persons, the respondents have been made parties in this.
All right.
So this is there. The other writ petitions are Rashmi Rekha Muzumdar's writ petition, first one. Then there's another writ petition 3717 of 2016. That is also by Rashmi Rekha Muzumdar. And 6901 2014 by Rashmi Rekha Muzumdar.
Yes.
These are the writ
Yes,
petitions.
all right.
So this writ petition is a part of the
Read
one.
the
of-
findings of the learned committee.
So 10 March 99, this, what I have shown, the circular, that has also been shown to the honorable single judge.
Yes. Read the findings.
Findings, your lordship will
Para
kindly
eight,
take up
Para 8 from para eight.
from, I think it starts from para
Read para
8.
8 is.
Explaining the cause of delay in challenging the promotion granted to the private respondents, the learned counsel for the petitioner has submitted that it is only when promotions were made in the year 2014 that the petitioners became aware of them being superseded, and therefore the writ petitions were filed. And as and when they found themselves aggrieved by the promotion of the private respondents impleaded in these 4 writ petitions. The learned counsel for the petitioner in his written note has referred to 13 case citations, apart from quoting a part of one of the said case in his written note. However, recital of relevant passages of none of the cases were actually referred before the court. In this connection, it is observed that in one of these writ petition, reference is made to the pendency of WPC number so and so and WPC number so and so before the High Court of Kerala. A copy of the common judgment in WPC so and so along with so and so have been downloaded by this court. On perusal of the said common judgment dated so and so, it appeared that the DPC of the promotion which were under challenge in these 4 writ petitions are a subject matter of adjudication before the High Court of Kerala. In the said judgment, reference made in section so and so of the Rubber Board Act 1947 and the Rubber Board Service Rule 19.
Continue to. After that bench, yes.
In item number 2, I filed an additional affidavit yesterday. I will be allowed to. Yes, ma'am.
What is the affidavit about?
Affidavit is that your lordship asks the clarification. I also take the clarification. Accordingly, director has filed the affidavit.
All right. All right.
Affidavit is only to support the fact that which I have said, my lord, that there are 6 persons against 3 vacancies, nothing else,
Right, all right.
I'll answer.
We'll take that on record.
my lord.
In which of these matters there was an order of transfer?
Yes,
One minute.
All right.
Item number 1.
The matters that the matters were heard,
Yes, sir.
the matter was heard,
Yes, yes.
finally. And judgment was reserved by order dated so and so. In the intervening period, the court was informed that even while hearing of the writ appeal was underway, a fresh order of transfer dated 24th July 2000.
27.
27.
27th July 23 was passed in supersession of the earlier order dated 20th April 23, transferring the appellant herein from DDSE Leparda District Basar to as Principal GHSS Namsai District, Namsai. Subsequently, when Mr. Goswami was asked to offer an explanation about this order having been passed while the court was in session of the matter, Mr. Goswami has placed on record copy of the order dated 28 July 23, whereby, the said transfer order dated 27th July 23 has been withdrawn or called back till further orders. Both the documents are taken on record. The matter shall be, the matter has been closed for, has already been closed for dictation for judgment.
If that's not so.
Closed for verdict.
I submitted my written note, perhaps not.
Yes, yes.
In writ appeal number 2, this 219, only the Mr. NN Chaudhary has placed on record, has filed the affidavit of the director.
My lord, two things are there, my lord. If your lordship allows me, my lord.
Hearing we have already.
Hearing,
No,
my
no,
lord, is
no,
over.
there are two things I just pointed out. Your lordship has said about noting. Now we got a constitutional bench judgment. That's why I want to just place it for
Sure.
the judgment of the constitutional bench judgment.
Citation.
1962, AR 1963 Supreme Court 395. This one? I just. Paragraph 9, my lord. Paragraph 9. The question therefore is whether he did in fact make such an order. Merely writing something on the file doesn't amount to an order. Before something amounts to an order of the state government, two things are necessary. The order has to be expressed in the name of the governor as required by clause 1 of Article 166, and then it has to be communicated. As already indicated, no formal order modifying the decision of Revenue Secretary was ever made. Until such an order is drawn up by the state government cannot, in our opinion, be regarded as bound by what was stated in the file. As long as the matter rested with him, the revenue minister could well score out his remarks or minutes on the final right fresh one. So if your lordship just recollect, 171 was a note, 171 was a remark that was made by the minister.
This is a different context, Mr. Das. Anyhow, we'll take it.
Yes, now, my lord. My lord, will just trouble your lordship with paragraph 10, my lord, if your lordship kindly permit.
Yes.
The business of the state is complicated one and has necessary to be conducted through the agency of a large number of officials and authority. The constitution therefore requires, and so did the rules of the business framed by Ras Pramukh of so and so. Action must be taken by the authority concerned name of Rasburg. It is not till this formality observed, action can be regarded as that of the state or hereby so and so. We may further observe that constitutionally speaking, the minister is no more than an advisor and a head of the state. Governor or so and so is to act with the aid and advice of council of minister. Therefore, until such advice is accepted by governor, whatever the minister or council of minister may say in regard to a particular matter does not become the action of the state until the advice of the council of minister is accepted or deemed to be accepted by head of the state. Indeed, it is possible after expressing one opinion about a particular matter at a particular stage, a minister or the council of minister may express quite a different opinion, one which may be completely opposed to the earlier opinion. So the opinion at 171, that was contrary, my lord, to what was made in note number 171, a remarks has been made. Now, my lord will kindly see another judgment of the Supreme Court, how this was referred. I'll just one paragraph I'll read, my lord. 2009. My lord, 2009. 2009, 1 SCC page 705, paragraph 43. Paragraph 43. I got some time because this matter, my lord, paragraph 43. In noting Recorded, Lordship got it, 43. A noting recorded in the file is merely a noting simplicity and nothing more. It merely represents expression of opinion by a particular individual. By no stretch of imagination, such noting can be treated as a decision of the government. Even if the competent author records its opinion in the file on the merits of the matter under consideration, same cannot be termed as a decision of the government unless it is sanctified and acted upon by issuing an order in accordance with so and so. The noting in this file or even a decision gets culminated into order, affecting right of the party only when it is expressed in the name of president or the governor, as the case may be, and authenticate the matter provided in so and so. A noting, now my lord, important, a noting or even a decision recorded in the file can always be reviewed, reversed, overruled, or overturned, and the court cannot take cognizance of the earlier noting or decision for exercise the power of judicial review. So, my lord, 170, 171, your lordship has asked, why, where is that order of reviewing that order? So, my submission 171, the minister has made a remarks that's amount to reviewing of the order as per the judgment of constitution, which is followed in this particular area. Last, I'll cover last, surplus of that post. That was not a pleading which was made. Even then, a query was put forward by the court. There is one judgment of Rajasthan High Court, my lord, where my learned, I'm thankful my learned friend who has, my lord, got the judgment. To what extent your lordship will accept, I don't know. But kindly see the judgment. Yes. My lord, this is, kindly see paragraph 2. Learned counsel for the present submitted order of transfer suffers from malafide as he has been posted to accommodate private person. Accommodation of private respondent is coming out from the fact petitioner posting against surplus post at so and so. Thus, the petitioner would be in addition to the sanctioned of so hence cannot be said to be in public and otherwise proves malafide the response. This is what your lordship during the course of argument. Even then, it was not a part of pleading. Now, how it was dealt at paragraph 9. So far as the argument is concerned, I find petitioner was posted vice person who was transferred to other place. The person who transferred approach tribunal stay exists in his favor does merely for that reason. It cannot be termed to be a case where petitioner has been posted against.
Petitioner was not posted against the surplus.
My lord,
That was the finding.
but my lord, this is what affidavit, I don't know, my lord. This is my
Yes,
submission.
we have only 3 posts.
This is my
That was
lord,
the affidavit.
this is not a pleading which was there
Doesn't
before.
matter.
It is not a pleading,
This
my lord.
position can't be changed, Mr.
Yes.
Das.
It is not a pleading,
This
that's my
position can't
submission.
be changed. This is a fact which is on the record.
And my lord, your lordship, I have cited judgment Wonder and Antox. Your lordship will kindly look into paragraph 14. What the 3 line appellate court would normally not be justified with the excess interfering with excess discussion under appeal. Under appeal solely on ground, you have to consider a matter so and so contrary conclusion, man. So lordship will kindly see the judgment of Wonder and Antox, paragraph 14. I am deeply obliged, my lord.
I've got nothing to say. I have completed. So far as this Entox malady is concerned.
You may give a short note, Mr.
I'll give a note to your lordships. Yes.
Both of you. Yes.
Well, so far as this Entox judgment submission is made on the basis of the Entox and Wonders Limited, my lord. That is a case where an injunction order was challenged and the Honorable Supreme Court was discussing about the power of the appellate court's power under Order 43. That is completely different. Your lordship is not sitting in appeal, my lord. In fact, my lord, repeatedly we are reminded by the several judgments of your lordship that your lordship doesn't exercise the power of appeal. It is a discretionary power under read.
Mr. N. Chaudhary, Additional Advocate General, Arunachal Pradesh, has filed the explanation in form of an affidavit of the Director of Secondary Education Itanagar to the inquiry made on 28/7/2023, which is taken on record. Arguments have been concluded, judgment is resolved.
We'll give a note, my lord.
Yes, there are 2 other appeals. My learned friend is appearing in one appeal and there is an appeal by the state.
The obvious request. Which matters? All right. Items numbers.
Item number, I think
One one and two.
No, no.
20?
27 and 28, my lord.
Where do you want?
Khatta hai.
Is jointly paid by Mr. Muzumdar and Mr. Ken Chaudhary and council representing the parties. Kamal re-notify on
7th, my lord.
7th August. No, then they'll not be repeated so soon. They are new matters. Our focus is on old matters.
17th, my lord.
17, lot many matters have been fixed already. That will go in September now. List on 7th September, yes. 7-9.
7-9.
Yeah, 7 September, no. It will not be good because there are four holidays. 12 September,
12th, my lord, can it be 13th, my lord?
14 then.
14th, my lord, yeah. Deep lord.
Yes. Yes.
Wait, please, your lord.
Hmm.
One more thing, your lordship has, with regard to whether I have stated it, the clubbing in the writ petition also, yes. In the second writ petition, it is there, in paragraph 11. Specifically has been stated. clubbing.
All right. Okay.
So that is there, your lord. Not only in the affidavit, it is also there in the second writ. Rashmi.
All right.
Rashmi.
Hmm.
Now, your lordship, I was reading the judgment of the honorable single judge in para 8, from where the first point that was with regard to delay has been considered. So I'll just read that.
That para you already read.
Yes, so para 9. This is the par contra argument by the learned senior counsel for the respondent has made a short submission to the effect that the order promotion which has been put into challenge in these 4 writ petitions are fallout of DPC meeting held on 21/7/2014. Here I have a small query, your lordship. Lordship has asked me, you have challenged the 2009 in 2014. So I said yes, 2009 in 2014, but your lordship did not ask me why you have, whether you have challenged in 2014 or not. It is there, it was challenged. So 2014 has also been challenged in 2014, wherein 2009 has been brought into record because 2009 there was no gradation list, so we didn't know that this has happened. So it has come in 2014, immediately after the promotions of 2014. It is submitted that the minutes of DPC has not been put to challenge in any of the 4 writ petitions. It is also submitted that petitioners is of general category and the private respondents impleaded in the 4 writ petitions are of reserved category. In this regard, it is submitted that the petitioners who belong to the unreserved class would not have challenged the promotion of SC category person. Referring to the rejoinder affidavit filed in WPC so-and-so, it is submitted that not only there were vacancies which were considered, but the position of the petitioner in WPC so-and-so was a serial number 86 of the general category, and the said petitioner was not found eligible. As such, case of the said writ petitions was not considered. It is further submitted that the prayer made in the 4 writ petitions, insofar as it relates to placing the petitioner above the private respondent is concerned, the same would have the effect of disturbing the seniority position of all those whose name appeared after the private respondents.
Yes.
In this connection, it is submitted that without assailing the DPC minutes of 21/7/2014 and without any challenge to the impugned OM dated 4/12/2009 in 3 writ petition except WPC 6901, the relief prayed for by the petitioners in the other writ petitions cannot be considered by this court. In respect of challenge made to the OM dated 4/12/2009 in WPC so-and-so, the learned senior counsel of the respondent has referred to the case of so-and-so versus so-and-so, AR 74 SC 2271. Wherein the Supreme Court of India has held that a person aggrieved by an order promotion, a junior over his head should approach the court at least 6 months or at most within a year after such promotion. And it is further held that it would be a sound and wise exercise of discretion for the courts to refuse to exercise their extraordinary powers under Article 226 of the Constitution of India in the case of persons who do not approach expeditiously for relief and who stand by and allow things to happen and then approach the court to put forward stale claims and try to unsettle subtle matters. The said ratio was followed by this court in a judgment order dated so and so, passed in so and so. It is lastly submitted that although the gradation list was not prepared, seniority position was maintained and the DPC had considered the seniority position as per the maintained list. Now, your lordship, 12, the rest not required 12. There is no dispute at the bar that the DPC is the authority competent to take into consideration the applicable rules in force governing the entitlement to promotion from amongst the list of persons who are considered eligible to be considered for promotion to the next higher promotional post. The learned counsel for the petitioner has made his meticulous submissions on the manner in which the DPC is required to consider the cases of reserve category candidates for promotion of quota earmarked for reserve category. He had taken pains to explain the distinction between shortfall of reservation and the number of backlog reserve vacancies in the cadre. This was done to stress on the point that as the vacancy position for 3 years was considered by the DPC together without taking into account the year-wise vacancy. However, by taking into consideration that the cadre strength of the post of ADO was 107. Nonetheless, in all the 4 writ petitions, the minute of the DPC meeting held on so-and-so has not been challenged. Therefore, the challenge to consequential OM dated 12/8/2014, 29/10/2004, impugned in WPC number so-and-so, and OM dated 16/12/2016, impugned in WPC number 777/2016, which are fallout of the DPC meeting dated 21/7/2014, is held to be not maintainable on facts and in law. Similarly, the minutes of DPC meeting held on so-and-so was not challenged in WPC number so-and-so, so-and-so, so-and-so. Therefore, the challenge of consequential OM dated 14/6/2016 is had to be not maintainable. The minutes of the DPC meeting held on so-and-so has been challenged in WPC so-and-so. However, guided by the ratio laid down in the case of PS Sadasiva Swami Supra, as followed by the court in the case of Middle Chandra Das on so-and-so, the belated challenge is held to be not sustainable in law, and because of the law, because by this time benefits are accrued to several persons, and in this regard, para 2 of the said case is reproduced below. I'm not reading the para, your lordship. Para 13. It may be mentioned that although the learned counsel for the petitioner has strenuously argued that in order to have an effective DPC, the gradation list has to be prepared annually, but to that effect, no prayer has been made in these 4 writ petitions. Moreover, in these writ petitions, prayer has been made for direction to the respondent authority to place the petitioners above the private respondents, which cannot be granted because by directing the respondent authority to place the petitioners above the private respondents, the seriatim of persons placed after the private respondents and those whose names appear before the petitioners would have to be altered. However, persons who are likely to be affected by such exercise have not been made a party respondent in these writ petitions. Hence, the relief for directing the respondent authorities to place the petitioners above the private respondents is hit by principle of non-joinder of necessary parties. Now, your lordship, under the facts of this present case, the cases cited by the learned counsel for the petitioners are not applicable because of distinguishable facts. It is seen that WPC number so-and-so, the petitioner had made reference to the interim order passed by the High Court of Kerala in WPC so-and-so. However, a common copy of the common judgment and order dated so-and-so passed by the High Court of Kerala in writ petitions number so-and-sos are downloaded by the court and perused. However, from the facts narrated therein, the learned counsel for the petitioner could not show if any gradation list, DPC, OMs and orders impugned in this writ petition has been examined by the said honorable court. Thus, the learned counsel for the petitioner could not show the relevancy of the said cases cited by him. Therefore, in view of the discussions, the challenge made to writ petition so-and-so fails and the writ petitions are dismissed. Second part, your lordship. In connection with WPC number 5815/2014, the respondent number 1, 2, and 3, Rubber Board, has not been able to show that in order to promote the private respondent number 13, namely D. Suresh, any DPC or supplementary DPC was held. Hence, the challenge to the promotion of respondent number 13 in WPC so-and-so is sustained, and as such, the OM dated so-and-so in respect of respondent number 13 therein is set aside by making the interim order dated so-and-so passed in WPC number so-and-so absolute. The other prayers made in the writ petition stands refused. So this part we are not challenging. Here, my learned Honorable Singles has taken into consideration the OM and had set aside. In other cases, that OMs are not taken into consideration and held that we have not challenged the minutes of this selection committee meetings. Your Lordship. This is one ground. Second is the stale ground. Stale ground, the court has itself said in 2014, we have come to challenge it. So the issues of 2014 and 16, where there are writ petitions in 2014 and 16, only 2009, the clubbing of 2009 was taken up in 2014. Though in 2000, from 2009, there was no gradation list. Therefore, they were not known to him. It was also urged there in this itself, in the writ petition itself. So over a non-joiner of parties, Your Lordship, what the court has said with regard to the non-joiner of parties, that these respondents have superseded us. We have made them parties. Now we are saying that you put us above them, because otherwise we are saying just for the sake of the moment. If we are put above them, what will be the problem with the persons who are junior to us? Nothing. They will remain as it is. How they will be affected in a chain reaction, Your Lordship? That is not correct. These three grounds are not correct. Secondly, if we take into consider the clubbing of the vacancies together, which is also illegal, then Your Lordship, again, the issue of backlog will come. Now, where is the question of first the backlog? Because there again, the rules I will point out, where the backlog, how they will do it with regard to backlog, that is there. Because they have made a submission before the court that these are backlog vacancies. So in that case also, they have not followed their own rules with regard to the backlog. Because backlog vacancies have to be reserved in a separate way. That they have not done. They have taken everything together, 24 posts, out of 24 posts, 19 posts to DSC. Now what has happened? Recently what has happened, I'll just give one document to Your Lordship, just see the document. This is the latest gradation list of the post of, they put the post above this post. Your Lordship.
What is not on record? What is the point bringing that?
Here this is what has happened. Not a single general category candidate is there in that post.
Maybe for that.
No, not maybe, Your Lordship. How can it happen?
We don't know. You have a right to challenge that.
No, I'm not. Because if this goes in my favor, then there is no question of challenging these. Everything will be, and that is why the judgment of clubbing I'll produce, 3 judgments are there. It has given the guidelines were given by the Honorable Supreme Court, how to do it and what happens if you don't do it. And in that case, when you don't do it and this type of a similar situation happens, how to go about it. That is there in the judgment. So I have given, I think the judgments have been given. If it is not there, I'll give another copy.
Yes. This, what are you passing on? What are these?
No, this is the gradation list here, recently.
2009, we are not taking that into consideration.
No, anyway, Your Lordship, I'm just trying to show that this is how it happens.
Absolutely, no, we told
This
you,
is
sir,
called reverse discrimination.
We told you we are
This is
not
called
taking into
reverse discrimination in service jurisprudence. I just wanted to point out.
whatever you
Things
want
are
to bring
happening,
on
going
record.
in such a manner. And it's very easy, Your Lordship, to dismiss this case. It will be very easy to do it. But it will be the most difficult to accept the proposition forwarded by me and do it, how to channelize the whole thing. That is where actually the law lies. Your Lordship was a lawyer. I have heard. And when one of my stalwart of this court has always told me that you first study the judge. So since Your Lordship was a lawyer, Lordship appreciate this is how things go, Your Lordship. If we don't urge, we are not getting any. And Lordship is very straight away on the very first point I found. The Lordship asked me 2009, you have challenged in 2014. But 2014, Lordship did not point it out at all to me. Then I knew, yes, I have been on the back foot. So I just wanted to point out how the single judge, Your Lordship, 3 points. Let us take the 3 points the judge dismissed the matter. Are these 3 points, Your Lordship, where is the necessity of going and challenging the, Your Lordship, the minutes of the committee when I'm challenging the OM? Is it correct, Your Lordship? Second, Your Lordship, where is the delay? 2014, I have come in 2014. 2016, I have come in 2016. 2009, yes, Your Lordship may say there is a delay, but I have explained that because they did not bring the gradation list at that point of time. Therefore, we could not come into this proposal. Then, Your Lordship, the third one, with regard to non-render of necessary parties, that anybody will say, oh, how can that be? Because these persons who are affected are already parties in this party respondent in this case, Your Lordship.
Yes.
Those who are not affected are nowhere there, Your Lordship. Basically, this part. Then, Your Lordship, I'll come to the judgments. I will be asking you. Oh, backlog. Yes. So one more rule that your lordship I'd like to point out with regard to the backlog, your lordship, that is OM dated 15/7/2008, page 163.
Yes.
This is the office memorandum dated 15 July 2008 with regard to backlog vacancies, your lordship. It has specifically, I'll read two paragraphs. The undersigned is directed refer to the department OM dated so and so, which provide that 50% limit on reservation would apply in current as well as in backlog reserve vacancies. The instructions were modified by OM dated so and so to the effect that backlog reserve vacancies of scheduled caste, scheduled tribes would be treated as a separate and distinct group and would not be considered together with the reserve vacancies of the year in which they are filled for determining the ceiling of 50% reservation on total number of vacancies of the year. It has now been decided to treat the backward reserve vacancies of other backward classes. Here that is not applicable, your lordship. So also as a separate and distinct group, and the same way as the backlog reserve vacancies of SC, ST are treated, thus the ceiling of 50% reservation filling of reserve vacancies would now apply only to the vacancies which arise in the current year, and the backlog reserve vacancy of SC, ST and OBC in case of direct recruitment and backlog reserve vacancies of SC, ST in case of promotion of earlier years would be treated as a separate and distinct group and would not be considered together with the reserve vacancies of the year in which they are filled for determining the ceiling of 50% reservation on total number of vacancies of that year. Two, it is important to note that there is a distinction between shortfall of reservation and number of backlog reserve vacancies in a cadre. The shortfall of reservation of a particular reserve category in a cadre means the difference between the total number of the reserve post for the category in the cadre. This is what he has, the Honorable Singhal has shown by showing that there was 107 posts in the cadre. So that is not applicable. Reserve posts for the category in the cadre according to the post-based reservation and the number of persons of that category appointed by reservation and holding the post in the cadre. On the other hand, backlog reserve vacancies of a category are those vacancies which were earmarked reserved for that category in an earlier recruitment year according to post-based reservation, but remain unfilled in the previous recruitment attempt on account of non-availability of suitable candidates belonging to the category and are still lying unfilled. The following illustration clarifies the difference between the shortfall of reservation and backlog reserve vacancies and the matter of earmarking reservation for SC, ST and OBC. Now they have given all these. Should I read it, your lordship? Because it is
absolutely your choice, Mr. Counsel.
I can read it, your lordship, but it has been explained in the earlier paragraph. Now this is an example, the illustration they are giving. Suppose there is a cadre having a total number of 1,000 posts, which are filled in by direct recruitment on all India basis by open competition. The number of SC, ST, OBC employees appointed by reservation in the cadre should ideally be 150, 75 and 270. That is 15, 7 and 7.5 and 27% respectively. When all the posts are filled, reservations are percentage. Suppose all the 1,000 posts stood filled in the year 2006, but the number of SC, ST and OBC employees appointed by reservation was 130, 75 and 100 respectively. There was thus a shortfall of 20 SC and 170 OBCs in the cadre in that year, though all the posts are filled. Now 3A, suppose 200 vacancies occur in a cadre in the recruitment year 2007, of which 20 were vacated by SC, 10 by SC and ST and the rest by unreserved category candidates. After vacation of this shortfall, the post shortfall of SC, ST and OBC in the cadre become 40, 10 and 170 respectively. Though there was a big shortfall of SC, ST and OBC in the cadre, only 100 of these vacancies could be earmarked reserved because all the 200 vacancies were current vacancies and the limit of 50% on reservation in their year would apply on these vacancies. So these examples are also given in their own OM. I need not further that. So they cannot go and appoint 19 candidate SC/ST out of the 24 selected. 26 and 24, your lordship. Initially 19 out of 24, and then in the 26 they have appointed, I think 60. So they have exceeded that 100% twice. So that is the second part where they fail. Their own OM doesn't support them. If you have backlog, I don't say, if you might have backlog. They have a backlog, then they should have it in a distinct group. There's no distinct group. You are clubbing all the vacancies together. Yes, call them and appoint them. And that too, put all these above me. Now the question will arise, why you have put all these above these people? They are because they are junior to us. Lordship may also put that question. They will say no, they will be put against the roster point. That is what they argued in the matter. That is not reflected in the judgment, but that was argued. Then there is a judgment, Bimalesh Sir Tanwar judgment of 2000. I'll place that also, where the Honorable Supreme Court says you can give the reservation and promotion, but roster point, they cannot go and fill up the roster point of a senior and put them above the senior cadres who are already there in the cadre. I was there in the cadre before anybody else was there in the first case. The second case, yes, she was promoted together. In the first case, I was promoted prior. Now, obviously, I am there in the cadre super. They were not even there in the cadre when I am there in that cadre. Now, how can they supersede me? Even if they supersede me, fine, they can supersede, not supersede, but they can come into that cadre and come into the next post. But I will have the seniority over them. Why I am not having the seniority over? This seniority they have somehow or the other put into the roster point, and then I have come down. This is the second part. Then, your lordship, with regard to the judgment I have already read, and the grounds that I have already, the zone of consideration, because they have clubbed the vacancy together, which is already shown. Now 24 vacancies, 25 vacancies, normally it is into 5. So it comes to 100. Now they are clubbing, if there are 12 vacancies or 5 vacancies, 6 vacancies, into 5 will be 30, 40. They have come into 100, 200 because they are clubbing the vacancies together. So because of that, the persons much who are not even in the zone of consideration were brought in. Even after the clubbing of vacancies, some of the persons who are even junior to them have also been promoted, who are otherwise not in the cadre. Then your lordship will kindly take for a moment the additional affidavit that was filed along with this writ appeal. 337, there's an additional affidavit.
Yes.
Here your lordship will kindly take up page 57. 57, when is it? Yes, 57. This is the proceedings of 2014, your lord, which the honorable single judge said was not under challenge, but we have got a copy subsequently under RTI and we have annexed it. That was filed in the affidavit in opposition, so we have annexed it. Now your lordship will see in the first paragraph, the department will promote DPC headed by the director, so and so, Deputy
Tell us the
Rama,
correct page, Mr. Manan.
page 57 of the additional affidavit. 57, annexure 4. 57, huh? Mhm.
Yes.
Annexure 4, this is the proceedings, your lordship. Lordship has got 57. It is the proceedings.
No, it's 7, Mr. Manan, it's
57 key होगा,
an affidavit, that's all.
No, in the not in the writ appeal, it
There are
says
few gradation lists next with this annexure J.
no annexure, not J, your lordship, then K, then your lordship will find page 57 there. The same that particular.
Yes, proceedings.
Yes,
All right, yes.
this is what the honorable single judge has pointed out was not under challenge.
Hmm.
So this is your lordship will see from the second paragraph I'll read. The number of probable vacancies for a period of 1 year is assessed as 31. There are 8 SC and 5 SC backlog vacancies and other replacement points. Now, according to the recruitment rule, the post is to be filled up by promotion from field officers with 7 years experience in rubber cultivation. The committee assessed the suitability of the following 69 field officers with reference to the ACS for the 5 years service record, general performance, etc. Here your lordship will find, I'm already promoted, so here I was not there, but I am just pointing it out. Serial number 2, Roshmi Rekha Mojumdar. Now your lordship will go to the next page, page 58. The next person who comes is at serial number 47, KK Kamalaxmi Lakshi. Then 48 is Markutti Baby. Then comes the extended zone, your lordship. Numbers are not given, what is their serial number. So in the extended zone, they have taken the 14, 15, 18, 19 persons. From these 19 persons, your lordship, page 59, based on the evaluation, the following panel of candidates was drawn in order of seniority for promotion to the post of Assistant Development Officer. Now at serial number 1 is Roshmi Rekha Mojumdar. The rest, your lordship, are down below. Then the respondents, private respondents come from page, the next page 60, the serial number 43, 44, then in the extended zone. Your lordship. Now, in what manner these people have gone over me, your lordship? On the same day we are promoted en bloc. En bloc. If they were promoted earlier, fine. But they were promoted on the same day, how they have gone above me? That's first question has to be answered. That has not been answered, your lordship, in this case. Now, in the next, the proceeding of 62, page 62. This is with regard to the proceeding of development officer, the next higher post, wherein this Prashanta Borua is also has to have been promoted, but was not promoted. Your lordships kindly see, as per the direction contained in interim order dated so and so, the rubber board, a select panel for consideration of promotion to the post of development officer. The committee set at 3 p.m. I'm not reading. Now the candidates, your lordship, no one is there. The Roshmi Rekha Mojumdar as well as the Prashanta Borua, Roshmi Rekha Mojumdar, both are not there. The respondents, private respondents are at serial number 5, 8, 9, 21. Then in the extended zone, all those who were even in the main zone were here in the extended zone. The extended zone, KK Kamalakshmi that I have said, Marukutti Baby SYZ, they are all there. And we were not even there. How can that be, your lordship? I was all throughout senior in the cadre. I was promoted prior. These are the two issues, your lordship, we have seen. Now, with regard to the judgments, I will not read all the judgments, is not required. Just I point out 2 judgments or 3 judgments. The first one, I think copies have been provided if it is there, or I can provide another extra copy.
Just give the citation.
Citation, your lordship, is already given in the my synopsis of. There your lordship will find that page 7 of my synopsis.
Yes.
Citations, page 7. There are clubbing of, I have given the citations in separate way. Clubbing of vacancies, the 3 citations, 96, 6 SCC, 721, then 2007, 9 SCC, 743, and 3 is 2011, 7 SCC, 789.
Yes.
With the accelerated promotion, see the seniority in the feeder cadre part. These are the 4 judgments.
Whether you made any such argument on this aspect? No.
Which one?
Accelerated promotion.
Accelerated promotion, I am not making a judgment. Because why I am not making it? Because they are given accelerated promotion, fine. But question is that they can be given accelerated promotion when?
There is no argument, Mr. Manan. We have not heard any argument coming.
No, I am not making any
Then
argument on
why
that.
you refer to
No, I am
this?
not arguing on that.
Very well.
Then reservation promotion, 50% ceiling that I have argued, your lordship, and these are the judgments I have given. And then seniority cannot be fixed in terms of roster point, which I have argued. They cannot be given the roster point seniority. This, there are three judgments in that. And there is with regard to the reverse discrimination, I have actually, that was not the argument in the single judge because that was subsequently I have come into. So if your lordship would like to, I can provide, otherwise.
That is your choice. If you want to do it, you have to do it through proper pleadings by filing an affidavit, bringing it on record. So that the other side can have a chance to rebut.
That, in that case, your lordship, let me not argue on that
Very-
because
All right.
let me not argue because I unnecessarily making another point here will not suffice anything because if your lordship is will take it up, the clubbing of vacancies would be enough for this case.
All right.
So if your lordship, I read the judgment or your lordship will.
That's your choice, sir. We are not giving any suggestions.
Yes.
Otherwise, you will just say we have been put on back foot.
Yes, yes.
It's
The judgment,
absolutely your choice.
no, judgments that with regard to clubbing and your lordship 50% I'll read. Clubbing your lordship first 96, 6 SCC, 721.
Please.
Paragraph 11. Your Lordship. It must therefore be held. Copy to DD. Copy to DD.
No, you
99.
keep on reading, yes.
Yes.
We'll get our book.
It must therefore be held that in view of the provisions contained in Regulation 5, unless there is a good reason for not doing so, the selection committee is required to meet every year for the purpose of making selections from amongst the state civil services officer who fulfill the conditions regarding eligibility on the first day of January of the year in which the committee meets and falls within the zone of consideration as prescribed in clause 2 of Regulation 5. The failure on the part of the selection committee
Get a book.
to meet during a particular year,
Here. Yes.
during a particular year, would not dispense with the requirement for preparing the select list for that year. If for any reason the selection committee is not able to meet during a particular year, the committee, when it meets next, should, while making the selection, prepare a separate list for each year, keeping in view the number of vacancies in that year after considering the state civil services officers who were eligible and fell within the zone of consideration for the selection in that year. Now, para 13. Therefore, while upholding the judgment of the tribunal that the respondent is entitled to seek fresh consideration on the basis that the selection should be made for vacancies occurring in each year separately, but in substitution of the directions given by the tribunal in that regard, the following directions are given. 1. The number of vacancies falling in the quota prescribed for promotion of state civil service officers to the service shall be determined separately for each year in respect of the period from 1980 to 86. The civil services officers who have been appointed to the service on the basis of impugned select list of December 86 to January 87 and were senior to the respondent in the state civil service shall be adjusted against the vacancies so determined on year-wise basis. After such adjustment, if all the vacancies in a particular year or years are filled by the officers referred to in para 2, no further action need be taken in respect of those vacancies for the said years. But if after such adjustment vacancies remain in a particular years during the period from 1980 to 86, notional select list shall be prepared separately for that years on a consideration of all eligible officers falling within the zone of consideration determined on the basis of vacancies of the particular year. If the name of the respondent is included in the notional select list prepared for any particular years during the period of so and so, and if he is so placed in the order of merit so as to have been entitled to be appointed against the vacancy of that particular year, he be appointed to the service against that vacancy of that year with all the consequential benefits. Next is 2007, 9 SCC 743. Para 11, 12, and 14, 15. However, the decisions of HR Kasturi Rangan and Nepal Singh Tanwar do not, in our opinion, deal with the other principle laid down in Union of India versus Bipin Chandra Hiralal Shah, wherein it has been stated that the selection committee should prepare a separate select list for each year. In our opinion, this means that there cannot be clubbing of vacancies of several years and there cannot be a common select list for these years. A select list can only be prepared for a particular year, and only those who are eligible in that particular year alone can be considered for selection in the select list. Even if the select list is not prepared in that year, very year, it will relate back to that particular year. In the present case, a select list had to be prepared for the year 1991. Hence, only those officers who were eligible for induction into IFS in the year 1991 would have been considered in the select list for the year 1991, even if it is prepared subsequent to 1990. 14. It is obvious, therefore, that clubbing is illegal, since clubbing has been done for vacancies arising between 1991 to 1995 in IFS. This is clearly illegal in view of the decision of Union in India versus Bipin Chandra Hiralal Shah. In view of the above, the appeal is allowed. The impugned judgments of the division bench as well as the single bench of the Honorable High Court are set aside. Resultantly, the impugned select list dated so-and-so is quashed. The state government is directed to prepare a fresh select list for each year separately, considering only those persons, officers who are eligible for selection in that particular year. This exercise must be completed as expeditiously as possible. Any selection made in pursuance of select list dated 95 stand quashed. Fresh selection and appointment will be made as directed above, no cost. Then the third case, 2011, 7 SCC 789. Para 21. The vacancies have to be determined as per Rule 10 of the rules 79 on 1st April of every year. If any fraction of vacancies is left over after the apportionment of vacancies in a manner prescribed, the same shall be appointed through the quota of various matters prescribed in continuous cyclic order, given precedence to the promotion quota. The appointing authority has to determine year-wise vacancies of earlier years, which were required to be filled in by promotion. If such vacancies were not determined and filled earlier in the year, they were required to be filled in the subsequent years. In other words, the emphasis of the language of these rules is on yearly vacancies, and they are required to be filled in with reference to each particular year. The vacancies required to be determined and filled in as on 1st April of every year for the vacancies occurring during the financial year as per rule so-and-so, so-and-so. Now, Your Lordship, I'll come to para 24. On reading of rule so-and-so, 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 conjointly, it is clear that promotions have to be made by DPC by the criterion procedure for promotion as applicable in that particular year to which the vacancy relate. The service experience of the incumbent who has been so promoted for promotion to higher post for any period during which he has not actually performed the duties of the post to which he would have been promoted shall be counted. It also requires that pay of a person who has been so promoted shall be refixed at the pay scale which he would have derived at the time of his promotion. But no arrears of pay shall be allowed to him. The government or the appointing authority has the power to order for the review of the proceedings of DPC held earlier on account of some mistake apparent on the face of the record or on account of substantial error affecting the decision of DPC, or even for any other sufficient reason like change in seniority, wrong determination of vacancies. Now you know, para 29. In light of this, we now come to the conduct of the government, which we cannot help but to comment upon. Right from 1993, 83, 84 till 93, 94, no examination has been conducted by the appropriate authority, despite the fact that they also issued notification for holding exams on a few of these occasions. If there was a representation for the Transport Inspector Union, it cannot be considered as a sufficient cause or reason for not holding the examinations for more than 10 years and cause serious prejudice to the candidates who might have sufficiently meritorious to qualify in the exams and to be considered for promotion to 50% of the post under the promotion quota. It is a matter of regret that the government can take such a stand before the court of law and expects the court to accept such a submission. It is ex facie untenable. Once the rules stand clear, the authority concerned is expected to act in accordance with the law and not to defeat the law. One who defeats the law by its unjustifiable and unsustainable act is liable for the consequences of such default. We fail to understand why the government and its entire hierarchy had shut its eyes to the gross violation of statutory rules over such a long period. So para 31, even after 93, 94, the process of selection adopted by the government cannot be accepted. The preparation of seniority list method of selection and clubbing of vacancies are apparently in violation of the statutory rules as aforementioned. The tribunal in its judgment has noticed Rule 24 so and so observed that if DPC held together vacancies of several years, yet the vacancy of each year should be determined and also filled up separately. In this regard, reference was made to the judgment of the court in Vinod Kumar Sangal versus Union of India. I have already referred. We do approve the observations made by the tribunal that on one hand, the department has treated the rules as sacrosanct, and on the other hand, right from introduction to the rules in 1917, and not even a single examination was held. The fallacious, in this part I will skip you, para 33. The division bench, while dealing with the judgment of the learned single judge and the tribunal, referred to the rules to some extent, and to fact that one vacancy, 5 eligible persons are required to be considered, and for 2 vacancies, 8 eligible persons should be considered, and that such proportion in accordance with the zone of consideration as specified under rules and so should be maintained. The High Court referred to the judgment of this court in coming to the conclusion that clubbing of vacancies is not proper, and that such a court could be adopted only in case of direct recruitment. The High Court directed the making of a completely fresh exercise and directed that the persons already promoted were not to be demoted, but promotion be made year-wise. Though for somewhat different reasons, partially accepting the findings recorded by tribunal, which we have discussed above, we would accept some of the findings of the tribunal and the High Court. But the conclusion arrived at cannot be accepted in its entirety. We are not concerned with promotion or otherwise or any relief to the appellants or any persons in service, but we must also ensure that rules are implemented and the selection is made strictly in accordance with the rules. We cannot ignore the fact that the government servant gets a right, though not indefeasible right, to be considered for promotion to the appropriate post to which he is eligible and entitled in accordance with law. In Union versus so-and-so, the court must keep in mind the constitutional obligation of both the appellants, central government and the state government. Both the central government and the state government are to act as model employers, which is consistent with their role in a welfare state. It is an accepted legal position that the right of eligible employees to be considered for promotion is virtually a part of the fundamental right guaranteed under Article 16 of the Constitution, and guarantee of a fair consideration in matters of promotion under Article 16 virtually flows from the guarantee of equality and Article 14 of the Constitution. It is equally true that the rule of fairness in government action is an essential feature. However, such fairness has to be founded on reasons. Usually, the providing of reasons demonstrate the concept of reasonableness, but where the statutory rules provide the circumstances and criteria, ambit and methods by which the selection should be governed, they would become the yardstick of fairness. In so-and-so versus so-and-so, this court held the essence of guarantee under Article 14 and 16 of the Constitution is fairness founded on reasons. Having discussed in detail the infirmities and illegalities from which the selection process suffers, we do, for different reasons, have come to the same conclusion as the High Court, while also issuing directions. Therefore, while setting aside the selection promotion order dated so-and-so, we further issue the following directions for strict compliance by all the authorities concerned and without any further delay. Fresh process of selection shall be held by the competent authority in accordance with rules as expeditiously as possible, and any case not later than 3 months from today. The selection by promotion for year-wise vacancy shall be filled in compliance of Rule 24. So and so, the authorities shall fill 50% of the promotion vacancies purely by merit, for which it will evolve the methodology, either by holding a qualifying examination as was being conducted prior to 92, or by any other examination which will satisfy the basic criteria of selection by merit. Remaining 50% of the promotion post shall be filled in by seniority cum merit, for which the DPC shall meet within the stipulated time as aforesaid. The vacancies would be clubbed only for the purpose of calculating in arithmetical figure, but will be filled in accordance with year-wise vacancies and considering the officers eligible for promotion to the post of DTO in accordance with seniority cum merit rule for 50% of the promotion post. And 8, the candidates now selected in furtherance of the directions contained in the judgment shall not be entitled to any areas of pay, because though their promotion may be relatable to the previous year, such promotion shall be notional without any consequential benefits. So here also my argument is on the same. They cannot be given the they can given it a notional promotion and we cannot given the, they can be given the consequential benefit without the consequential benefit. That is basically my case, because now after so many years, if I'm even promoted there, I'll get the consequential benefits. I will be given the notional promotion without the consequential benefits. So these three are with regard to clubbing. And with regard to one case, that is what I referred that with regard to roster point, seniority in terms of roster point. Here, your lordship, is a very recent case. The other case which was allowed by this honorable court, I have just read with regard to D. Suresh, that was, I read it in the last part of the judgment, which was that they have, there they have, what they have done, they have actually promoted him and giving him retrospective seniority from the day this single judge judgment was given, wherein his case was set aside. His promotion was set aside, that given him the retrospective effect from that. Then we filed a writ petition. This Prasanta Boro again filed a writ petition. And in this writ petition, this roster point was taken into consideration, which they argued. And then this honorable court, the honorable single judge, has set aside his promotion with retrospective effect. And thereafter, they have issued an order reverting him back to the original post here. And this judgment, the next judgment of this honorable court in WPC 121 of 2022, this is with regard to seniority that cannot be fixed in terms of roster point. Here, in the honorable single judge judgment, this was on 29th May 2023, very recent judgment. Yeah. Here, your lordship will find that I think that judgment of Diasanata, Bimleshwar Tanwa, Sumono judgment. Sumono judgment too. Bimleshwar Tanwar or Sumono judgment too. Amar WPC 21. 121 of 2022. What bole thi till your lordship they find out, I can just read the paragraph. It is paragraph 15, your lordship. Since the respondents have taken a stand that such a recourse was adopted so as to give adequate representation to reserve category candidates in the cadre of DO, it would be necessary for this court to discuss the law laid down in the case of Bimleshwar Tanwar versus State of Haryana and others, reported in 2003 5 SCC 604, and Manoj Parihar and others versus State of Jammu and Kashmir, reported in 2022 Supreme Court 556. So Bimleshwar Tanwar is quoted by this honorable court. An affirmative action of Article 16(4) of the Constitution is meant for providing, Constitution is meant for providing a representation of class of citizenry who are socially or economically backward. Article 16 of Constitution of India is applicable in the case of an appointment. It does not speak fixation of seniority. Seniority is thus not to be fixed in terms of roster points. If that is done, the rule of affirmative action would be extended, which should strictly not be in consonance with the constitutional schemes. We are of the opinion that the decision of so-and-so does not lay down a good law. So basically what Bimleshwar Tanwar said, that you can give them the, you cannot give them seniority on the fixing on roster. The seniority cannot be given on the basis of roster, even though it is on the basis of, it is your lordship. It is against the Article 16 of the Constitution. And Manoj Parihar case, that is 2022 Supreme Court 556, again that has also been quoted. Thus, the principle of law discernible from all the aforesaid decisions of this court is that roster system is only for the purpose of ensuring that the quantum of reservation is reflected in the recruitment process. It has nothing to do with the interest of seniority among those recruited. To put in other words, the roster point do not determine the seniority of the appointees who gain simultaneous appointments. That is to say, those who are appointed collectively on the same date are deemed to be appointed on the same date irrespective when they join their post. The position of law is discussed about could be said to be prevailing even while the Court of Jammu and Kashmir decided by a full court resolution to determine the seniority on the basis of roster point, which has been set aside by Manoj Parihar's case. There's another case of Bharati Dastia, same, your lordship, and on the basis of this judgment, this court has set aside the roster point seniority of this. And the judgment of Vimlesh Tanwar and your lordship Manoj Parihar, that also I'm providing to your lordship. Manoj Parihar, I cannot get the copy of, I have taken it out from the net. So the specific your lordship SCC or something is not written. I'll give a copy of this, these two judgments.
Yes. That's all.
That's
Yes. Sukhnath.
Well, as regards the decisions relied on the point of clubbing of vacancies. In fact, well, the 2011-7 SCC, it has referred that the vacancies, clubbing of vacancies for the arithmetical purpose, it is allowed. But on this, for making submissions on the case laws, lordship can give you a short opportunity, not at least not on today, one day time may be given. Otherwise, on the merit of the case, but the in the additional affidavit, they have filed an affidavit and two proceedings has been relied.
All said and done.
Plotted.
Let us know. A person who was born in Kedar, this appellant in 337, much before these promotees.
Plotted.
How could he be ousted from those? What is the justification for that? The second candidate, we can understand. She was promoted subsequently.
But
What about this person?
in our affidavit, we have said that for the post of the next cadre promotion, the residency period of service is required is 3 years. That particular service is all the persons are having. And when the vacancies were calculated, then
What was the hot haste to hold the DPC without issuing the gradation list? How does the candidate know that what is his position, whether he is coming in the zone of consideration or not? So a person who is senior, suddenly overnight he finds that his juniors have been promoted without there being any disclosure.
but his position, the person can find out his position from the office, although the gradation list we have said.
Man, you have held the DPC without issuing the gradation list. There is no dispute.
No,
2009.
seniority list is maintained, we have said in the affidavit.
When was the last seniority list issued before 2009? Tell us from the pleadings. On judgments, we'll hear later. What about that on
Grad-
facts?
Gradation list, we have not, that it was not, in fact, we said that the gradation list was not published and.
So what was the criterion for taking into consideration the names when you undertook that exercise of DPC in 2009?
But in our affidavit, we have said, Lordship. The affidavit in opposition is, they have annexed in the affidavit subsequently filed in the writ appeal, 337 of 21, There, paragraph 6, we have said at page 42. The first portion we denied, but in this regard, the deponent respectively state.
Mr. Mazumdar, read his written note.
Lordship.
DPC proceedings 1910-2009.
Not
Rekha Mazumdar was at serial number 2.
Yes, but she was.
How
promoted. She was promoted
When?
in 2009. That,
No.
but page 50, page 56. Page 57. It starts at page 57. Page 59, kindly come, Manoj.
Yes.
Page 59.
59.
Based on the evaluation, the following panel of candidates was drawn in order of seniority for promotion to the post of ADO in the pay band of so and so, so and so.
Page 59.
in the affidavit, in the, affidavit, they have filed one affidavit in the appeal,
Huh.
337 of 2021. Yes, yes, my lord.
Yes.
There, page 57, a proceeding is there, my lord. It continues to page 59 also.
Hmm.
The decision taken at that time, the proceeding, the decision, based on the evaluation, the following panel of candidate was drawn in the order of seniority for promotion to the post of ADO in the pay band of so and so. There, the first name is of Rashmi Rekha Majumdar and some handwritten note is there, my lord, promoted on 4/12/2009.
You are reading at page, this starts from page 57. Where are you reading at?
I'm, Lordship, may kindly come to page 57, third page of that proceeding.
Annexure 4,
It is annexure.
third page.
Third page, you know.
Yes.
59.
Lordship has seen Rashmi Rekha Majumdar,
59.
page 59, yeah.
No, yes, yes.
Lordship has seen Rashmi Rekha at second, at serial number 2 at page 57,
ADO, yes.
ADO, and
Oh.
page 59, Lordship has seen Rashmi Rekha Majumdar is at first, my lord.
Yes.
So this is the, based on the evaluation, the following panel of candidate was drawn in order of
So
seniority
she was promoted.
for promotion.
And then in the next promotion,
Lordship,
what is the say, what is the position? That is where the crunch lies.
Lordship.
Hmm.
Although they said that this 2009 is not under challenge, this is of 2009, my lord. Page 61, Lordship will find the date.
Yes.
This is of 19/10/2009.
Hmm.
This was not challenged, my lord. After, in 2015, after 5 years.
Hmm.
The
Mr. Nath,
page 62.
come to page 62.
Yes,
Yes.
page 62.
Where does Rekha Majumdar go from this list? Why her name disappears in the list of candidates?
No, my lord,
Who are-
my lord, Rashmi Rekha Majumdar, the persons who were promoted in 2009, they are not the only person who are already in the ADO cadre.
Hmm.
They were promoted in 2009. My lord,
Hmm.
lot of ADOs are there already in
So
the ADO.
this list, where is the gradation list? There is the issue.
Lordship.
Where is the gradation list? How do we
Lordship.
find out? All eating in the dark. Who was sitting at what position?
In fact, for the gradation, one gradation list that they have annexed. That project.
You are not prepared, Mr. Nath. Need to even on facts, you are not ready.
My lord,
Where does this list come from? You just tell us. What was the position? What was the position of these persons at page number 59?
my lord, page 59, they are the eligible persons.
So where from this list comes? Why is Rekha Majumdar not there in this list?
At 62. At 62, because, Lordship,
Yes,
at 62, because these are the persons, they are already in that particular cadre.
there must be a seniority list
Correct,
which shows their position in the cadre.
correct.
So where is that list?
That list,
Without having any gradation or seniority list, can you proceed for DPC?
my lord, a list, Lordship will find a gradation list of employees, as on 31/12/2006, it is at page 106, 103.
After 6 months, water has flown. So what is the position thereafter? How many must have retired? Many must have been promoted. We don't know. So when you start the process for promotion to ADO, from ADO to DO,
That is.
where is that list
Lordship.
of people in zone of consideration?
That list they have not prepared, my lord.
Where is the gradation list, Mr. Manna?
Lordship, from 2006
Two,
to, there is no gradation list, and the gradation list.
as on
came-
date.
Yes, on 21 it is.
21, it is there, Lord.
So then how this exercise of 2014 was done, sir?
But they have maintained the seniority position, although the gradation list was not published.
Let us see. Is it a part of pleadings, part of record?
But we have said so, Lord.
Let's see, read.
In the affidavit, we have said so, Lord.
Yes.
Okay.
Page number. You just ask us, Mr. Nath, just a simple question you answer. Whether there can be any exercise of recommending names of to the DPC without preparing a seniority list. Can it be done? Where do you get the names of the candidates in zone of consideration? With transparency. Otherwise, you can pick out a n number of persons, your blue-eyed persons, send them to the DPC. What prevents you from doing so?
Although the gradation list, admittedly, gradation list was not published, and there.
So then your process, what should be the fate of your process? You tell us, rather than us telling you. When you are arguing on law, give us one Supreme Court judgment which says that DPC can be convened in a process of promotion without having a seniority list or a list of persons in zone of consideration even.
A list of persons in zone of that.
Where is that?
It is there before the authority, but the gradation list was not published. It is a fact. It is a fact. In fact, we have said.
So just look at the language at page 262. Just
Kindly come to page 199.
page 62, read the language.
191.
Just hold on. Read the page proceedings at page 62. As per the directions contained in interim order dated so and so, a departmental proceeding, DPC headed by so and so in charge was constituted to prepare a select panel for consideration, considering promotion to the post of development officer.
Correct.
So where did they get the information from of whose names are to be considered?
But kindly come to page 191 in the appeal.
191.
191. Logic.
Yes.
But we said that the board is maintaining seniority list of all employees by keeping establishment register for each cadre. From the said seniority list, SC/ST candidates with required experience as per recruitment rule. For
Sir, where is the list?
That
why was it not placed on record?
It is not placed. It is not placed. But that otherwise we have. We can place it.
Then give an explanation. What was the position of Rekha Mazumdar on the as on the 2014? What was her position?
That I can do. That I can.
So show it right now.
In fact, in affidavit we have said that
Yes.
she is her position at she was at 86. We have said so.
How does she go down at 86 without showing the position of the persons you have placed above him, above her? We don't know. The persons may be junior. They may have been born in cadre. They are left later on.
The list could have been, if the gradation list would have been very clear if it would have been prepared. But
What list you were maintaining? Where is it?
that
At Seriatim, there must be a list with reference to the entry of the
Yes,
person
yes.
concerned in cadre.
Yes.
Where is that list?
Well, that list is not available right now, but we have the seniority list of establishment registered list we have. That we have, that I can put.
All right.
And
Then
according to
place
that,
it on record.
her position is at 86. That is what we have.
After arguing the matter for some time, after arguments were heard for some time, Mr. Nath, representing the respondent, Rubber Board submits that the exercise of promotion undertaken in the year 2014 was based on a list maintained in the establishment section of the board. Right?
Seniority list of
Seniority
all
list.
employees by keeping establishment register for each cadre. That is
Maintained in the establishment
logic.
cadre
Logic.
of the section of the board.
Logic.
He shall keep the officer in charge present in the court with the said list oblique register.
The head office, all these records are at Kerala, Malad.
Wherever Kerala is in India only.
No, that's true, Malad.
Get them on mail.
Lordship, in mail I'll get and I'll place. Malad. The officer concerned from here is a zonal office is there, that officer.
Whatever,
Logic.
keep the officer concerned present in the court with the record on the next date.
Logic.
Re-notify on. August.
Logic. That position would be.
Yes.
Much obliged.
Item number 29.
My lord, the subject relates to premature retirement from service upon completion of 30 years of service, my lord. This is under Rule 48 of the CCS pension rules.
The other side.
My lord,
Madam,
council is there, council is there.
all right.
My lord,
Yes.
Before going into the depth of the case, because if I have to distinguish the learned single judge's judgment, my lord, there are 6 Supreme Court judgments that the learned single judge has relied upon, which I would have to distinguish on facts. But before going into that, my lord, I would like to place that similar issues, my lord, fell in Assam Rifles for consideration before the Meghalaya High Court. The division bench therein, my lord, has held that communication of ACR before taking decisions of compulsory retirement is necessary. Accordingly, my lord, series of other cases have been decided and the Assam Rifles have complied with all these orders and people have been reinstated back into service.
Okay.
So now there are 2 set of rules being applied, my lord. Petitioners here are, my lord, being treated
Do you have a copy
differently.
of those judgments?
My lord, I have cited the division bench judgment here.
Where?
Lordship would see at Annex of 4.
Was it argued before learned single judge?
This was not placed, my lord. In fact, subsequent judgments and compliance orders also, my lord.
So then that was a relevant fact to be,
Yes, my lord. The
Drawn.
issue is same, my
where is that judgment?
lord. My lord, page 117, Annex of 4.
Madam, would you like to respond to this? What is your response to this? In the same service, same cadre, you are treating 2 sets of employees differently. Yes, Union of India, Joseph KS. You got it?
My lord.
Is she having the judgment or not? Are you having the judgment? Page 117.
117. Yes.
Hmm.
Para 46, my lord, is the conclusion. Page 1.
46.
Para 46, page 128.
Compulsory.
Basically relying on Devdutt and Sukhdev, my lord. That communication of ACR, even if it is good, if it is otherwise, my lord, not up to the benchmark, it has to be communicated.
Has to be coming.
So opportunity of communication and representation was granted.
Yes.
Thereafter,
For
they will
upgradation.
take
the
a fresh
opportunity.
decision, my lord.
Whether it was implemented or not, or they have filed any SLP, that
They have said that it has been implemented. That is the order. Next order. The next order, Ms. Pathak. Where is the
No, no, no,
implementation
my
of this judgment?
Implementation, my lord, I have separate orders, my lord, that are not on record, because
Yeah,
I,
again,
based on this, I had argued other matters before the single bench. Those orders are being complied with, my lord.
But then you have to apprise them that
Well,
you have complied with the order, or at
In
least
fact, in fact,
bring it on record through an
My
affidavit.
lord, I would.
Then they will have to respond.
My lord.
Mr. Pathak submits that in an identical scenario, division bench at Meghalaya has ruled that communication of an adverse ACR, which is made the basis of compulsory retirement, is essential. And in the event of failure to do so, the action of compulsory retirement would be vitiated. He has drawn the court's attention to the judgment rendered in the case of rendered by Division Bench of Meghalaya High Court in the case of Union of India versus Joseph case reported in 2022 volume 3 GLT 284. He further makes a statement that the Assam Rifles, being the employer, have complied with the directions given in the said judgment. He may bring this fact on record. There are more judgments to the same effect.
My lord.
He further submit that few more judgments have been rendered by the Meghalaya High Court on the same issue, all of which have been complied with by the employer. He may bring these facts on record through an affidavit. 10 days time is granted. Mr. Pathak for doing the needful list up 10 days. Through an affidavit so that the respondents
My lord.
can take instructions on this submission of Mr. Pathak.
Item number 30,
May I plead on this? My lord, I am appearing on behalf of Mr. S.B. Loskar. Unfortunately, he is not feeling well today. He was
He
here.
stated that the arguing counsel, Mr. Laskar, is not well. A request is made to adjourn the matter. Please stop 4 weeks as please.
Obliged.
What is the matter by the way, madam? Madam Bhattakar?
Lordship, this matter pertains to actually a non-existent post, Lordship, that persons were appointed.
Okay.
Item number 31 and 32.
Please, your lordships. Lordship, in this matter, lordship, the arguing counsel, Mr. Raju Bhattacharya is down with viral fever, lordship.
He stated that arguing counsel, Mr. Borpuzari.
Can we be fixed on eighth, my lord?
What is the matter,
My
Mr.?
lord, if land, my lord, acquired without hearing objection, my lord, highway. And without, my lord,
Arguing counsel, Mr. Borpuzari is not well. Mr. Chaiwala, senior counsel, Mr. Chaiwala, representing the appellant, pleads urgency. Pre-notify on 10th August as well.
much.
And the like.
Item number 34.
Same, you are representing, all right. IOCL,
IOCL, my lord. On the last occasion, my lord, here the matter relates to the appointment and selection of LPG distributor, my lord. The
who is
Last
there for
period.
IOCL, someone is there? Yes.
the
All are represented, all respondents? You are representing, who is representing IOCL? You're there, all right, okay.
my lord, the main issue is whether I am the resident of that area or not. How the two categories of certificate, my lord, I am.
Can we read the findings first before proceeding?
Yes, my lord. It is starting from relevant portion, my lord. We'll find from page number 1.
Para.
The last paragraph, my lord. 195, para 24, my lord.
There are almost 12 documents filed by the respondents which indicate that you are not a resident of the place where the dealership was being offered. That is reflected in para number 18 of the judgment.
18 of the judgment.
Yes.
My
Then
lord,
it becomes a disputed question of fact.
it is disputed, my lord. My lord, my respectful prayer will be to peruse one document 168, my lord.
Let us see the finding first. Para 22.
Para 20.
Further improvement has been tried to make regarding the residential status of the land, which was purchased on 22nd January 14, admittedly after the date of advertisement. And the requirement was that the applicant should be a resident of that area.
Resident, my lord. I will satisfy, my lord, from the document itself, my lord.
Okay, that's
My lord has come to the crux of the whole issue, my lord, whether I'm the resident or not. The first document, my lord, I'm relying is page 168, my lord.
what is the status? Was there a stay by this court?
Yes, my lord, status in my.
Status quo.
Status quo. Liner single judge orders, my lord, was placed in abeyance, my lord.
When was the status quo order passed?
It was on, my lord, 24th February 2020.
24th February, yes.
24th
All right.
February.
What document are you referring to?
Yes, 168 is the first document that I'm relying, my lord, issued by the Revenue Authority Circle Officer, my lord. This was in regards to the complaint that I am not the resident of their area, my lord. Circle officer has come in the picture.
What
In
is the area where the
This is in the
dealership
middle
was to be
portion, my lord.
set up? What is the place where the dealership was to be set up?
Sudarshanpur part 2 and 3, my lord.
So this report itself says
Yes, my lord.
she is a voter of Rajeshpur, but residing in so and so,
Yes, my lord.
residing in a rented house.
Yes, my lord. And then thereafter, my lord, again, the same authority has again constituted on their own, my lord. IOCL authority has constituted a team, my lord. And then their finding, my lord, can come to 145, my lord.
What about the land which you acquired
Land,
was
my lord.
subsequently?
Yes, my lord. It was the advertisement location was for part 1, part 2, and part 3, my lord. I have been residing in the area from 2005 because
That's all right, but the land as per the single judge's finding, you
2000
acquired the land subsequently.
2014, my lord.
Then how do you qualify?
A qualified, my lord. My lord can come for a moment, my lord. How I have qualified. Page 38 for a moment. They have issued these guidelines, my lord, revised guidelines in the year 2014, my lord, June, my lord.
14 guidelines, how would they apply to you? This is a selection process of 2013. 14 guidelines, how they would come to your aid? You are not having the land on the date of the advertisement, last date. Then you otherwise ousted. Why do we need to go in the residential part of it?
My lord can.
Let us see the advertisement.
Yes, my lord. Page 26, my lord.
26, yes. Let's see the conditions.
Yes.
I have decided many matters on in the single bench in Rajasthan. The land must have been acquired before the advertisement. But there is a cutoff date, then before the cutoff date. Let's
Here,
see.
my lord, statement will come to page number 27, my lord, eligibility criteria. The word written, be a resident either of the Gram Panchayat.
Just
or
hold on.
Advertisement was on 29/12/2013.
Hold on. This in addition to the residence, what about the land?
Yeah. How?
The applicant should own.
Yes, my lord.
Come to JAA,
Yes, ma'am.
28.
28.
Should own. So you are not owning it as on the date of the advertisement, chapter closed. What more is required? We did not go into anything else at all. Can you dispute this fact?
I'm not disputing, my lord.
Then what remains?
My lord can peruse only for a second, my lord, 145.
Yes, please. 145.
And the IOCL authority has verified, my lord, because they have.
Just hold on.
Yes, my lord.
$145. Verification of what? A residence certificate. We are not even going into that. You are not having the land as on the last date. Does this advertisement give you the liberty to acquire land subsequently? Read, there are some advertisements wherein the land can be acquired subsequently.
Here it says, on the day of advertisement, my lord, own land 28, my lord.
So that is not there.
But they have revised their guidelines in the year
Where
2014.
2014 guidelines would not come to your aid, sir. Guidelines which were prevailing earlier, or the conditions that is.
Yes, my lord, my respectful prayer will be to peruse 145 for a moment, my lord.
Yes, let's see. All right, where is the reason for rejection? Let us see.
Not my lord. LOI was issued in favor of me, my lord.
Issued in your favor.
Yes, my lord. Page 82.
All right, let's see that.
My lord can come to page 145 for a moment, my lord. This was the position taken by the IOCL, my lord. The respondent.
Who approached the court in the raid?
My lord.
One of the
Participants.
What? And
You are representing the party.
Page 80.
No, IOCL has not rejected the candidature on the ground that the land was not acquired.
What has happened is there were the multiple rounds of litigation. Finally, the second judge passed an order after it was not back.
The question here is that you have not non-suited the candidate or rejected the candidature on the ground that the land was not owned before as on the date of the issuance of the advertisement. That is not your ground of rejection. So in all probability, you must have been you must have drawn the things from the 2014 guidelines, wherein land can subsequently, alternate land can even be provided. Yes.
That's the stand, my lord. I am respectful submission.
Alternate land will carry that criteria, that it has to be owned before the last week of submission of application. For that.
No. That can't be.
But here the advertisement is just being minus the guidelines.
Then you have not rejected. 2000, let's see the 2014 guidelines. What do they say?
why I'm emphasizing on 145, my lord, that will make the position.
All right,
clear, my
let's
lord.
see 145. Yes.
The deponent back, paragraph 12, my lord. The deponent back to state that during the field verification on the credential of the respondent number 6, the residence certificate issued by dated so and so was sent for verification before the circle officer Lala by dated so and so. In the reply, circle officer Lala by letter dated so and so informed that the residence certificate dated so and so has been verified, and it appears that Srimati Subhadita Nath is a voter of Rajeshwarpur but residing in village Sudarshanpur Part 3 from 2005. Then after continue what are the certificate that I have given, my lord can come to page number 147, last paragraph. In the light of the above, the applicant Srimati Subhadita Nath cleared all required criteria, which state that the applicant should own a plot of land. Own means having clear ownership of title of property in the name of applicant, family members. My lord can come to when they have filed this affidavit. This is in page 138. It is in 15/3/2022, my lord.
This is the stand of the IOCL.
IOCL.
They were supporting you in the writ petition.
Yes, my lord. All along.
Okay.
And now, my lord, on the last occasions, my lord, pointed query was, since there is a dispute regarding my residential status, I have made the party circle officer, additional deputy commissioner. What was their stand, my lord, was specific question was. So, my lord, my learned friend can apprise this court.
What is your stand? Your circle officer certificate says that she is a resident of that area. Not presently, even then, the certificates which were pointed out, let us see. Let us see the certificate. Where is the certificate you are pointing out, Mr. Counsel?
Yes, my lord, can come to page, my certificate, I am referring 168, my lord.
168.
And then
Verification by the authorities.
circle officer, my lord.
Circle officer.
Revenue authority, first revenue authority, my lord, in Assam. Of Sudarshanpur Part 3 from 2005 with family, which falls under the Sudarshanpur Kalachada GP, my lord. This is the letter dated 2003/2015, my lord. My lord can come to page number 170 for a moment, my lord. The second letter I am relying, that was in the year 2015 March. Then again, in the month of November 27th, my lord, the same circle officer, against there
So
was.
this house you purchased after the issuance of the advertisement.
That is admitted position, my lord. In spite of that, my lord, IOCL authority has reconfirmed my status, my lord. I'll come on record.
That's
This is on
right.
record.
Ultimately, the satisfaction of the
The
authority.
IOCL, that is the whole trust area, my lord. And then my lord can come, very interestingly, my lord. My lord can come to page number 175, my lord. That will clear everything, my lord. 174 is the letter, my lord. Again, in revenue authority, my lord, one authority has gone higher, my lord. It was circle officer. Now ADC has come in picture, my lord. Additional deputy commissioner. Additional deputy commissioner has conducted the inquiry, and he
Where are
has
you reading? Where are you reading?
174, my lord.
174.
Yes, my lord. This is as latest as 2020, my lord. October 9th, my lord. The additional deputy commissioner.
This is the status of the land owned by you.
Here, my lord, the godown will be constructed here only, my lord.
No, that's all right. That's all right.
Now, the third stand, my lord, that the revenue authority has taken as late as 2000.
All right. Was this a ground of challenge before single judge that you acquired the land subsequently?
No, my lord.
No.
That is what my IOL was issued in favor of me. IOC has verified, reconfirmed, and thereafter they have again given me the green signal to construct the godown, my lord, which I have done. I have
already constructed.
I have already constructed the godown. And my lord can come to my letter of intent, my lord, at page 82, my lord.
82.
Second paragraph, my lord. Please refer your application serial number so and so, subject to the so and so. It is intended to offer you LPG distributorship at Sudarshanpur Part 2 and 3, Kalachada so and so. Then the second line, my lord. The LPG storage godown should be approved and licensed by
All right. What
petroleum
do you
authority.
say, gentlemen?
Lordship.
Lordship.
Yes. Lordship, I beg to refer to Lordship to case number 179.
Sure.
This is the application, this is the first phase. Lordship, I am, Lordship, our read petition has not been completely annexed, Lordship. Only the petition part is annexed, but the annexers has not been annexed. So therefore, some document we have received through RTI, it could not be now.
Petition, they have not filed all documents on record.
Lordship.
Which
Lordship.
document, my lord?
Lordship, annexers has not been annexed, Lordship.
My lord, in the process, I am conscious about the fact that if it is supplied to me, then definitely I'm duty bound, my lord. If it is not, my lord can refer the specific which application that we have not enclosed. my lord,
What
along with the
document they have not filed? Let us see the index of the writ petition. All right, come to the index. Come to page 10.
Lordship,
Where is your writ petition?
copy of the writ petition 103.
Yes,
to
103. Where is the index?
Index, my
There
lord.
are, how many annexures are there? Let's see. Annexure 17, annexure 18. Tell us which annexure has not been placed on record.
Lordship,
There are 18 annexures. Huh?
There is no annexure. Only the petition part. There is no annexure.
There are annexures. Annexures 174, that is a part of those annexures, P13. No.
Lordship, our writ petition ends in 20 and annexures starts from in the 5277.
What do you say, Mr. Council? Why have you not filed the annexures on record?
This is the annexure, my lord.
These are the annexures.
These are the.
No, Lordship, Lordship.
We'll verify. Just hold on.
Lordship.
That's not a very big deal. Yeah, all right. It can't be. Annexure 1 is the advertisement. So advertisement probably you have annexed in the beginning of the
Yes,
appeal
my
itself. So annexure 1 is there.
Yeah, annexure in vernacular, my lord can find for page 35.
Voter list and the residential certificate issued by the revenue circle. What you do is, Mr. Council, you verify this fact. And council appearing for the private respondent, Mr. So and so submits that the petitioner has not annexed the complete set of annexures filed along with the writ petition. Mr. Your good name, please. Mr. Laskar.
A.S. Tapadar, my lord.
A.S. Tapadar, pray for short opportunity to verify this fact and to remove the deficiency, if any.
Yes, madam, I'm deeply obliged.
List in after 2 weeks.
I'm deeply obliged, ma'am.